want to thank a few people. First of all, thanks to the Spokane Resource Center for everything everyone did here to make sure this room was set up and have us hosted. Thank you to Vera. We have 3 representatives from Vera back again for a 3rd meeting, trekking across the country. Thanks also to Diane Lindquist, our criminal justice data analyst in the back, who's done an immense amount of work validating data for this project and also developing new reports related to our jail population. Also, I want to introduce and thank Kelsey Kamatomo, who's our newest team member. Many of you have met her already, but if you haven't received emails from her yet, be prepared, you'll be getting more. Kelsey has done everything to make the logistics possible today and has also done quite a bit to support our research over the past several weeks. So thank you and welcome. And then I also just want to thank everyone here for continuing to make time to be present and engaged. I know that it is a process that we've had to be a little bit flexible with in terms of timelines. We've had lots and lots of meetings, and I just want to appreciate your continued engagement, and I would ask that you continue to raise weaknesses in our proposals and point out blind spots, because I would much rather have you be the lone voice of dissent or support now than have us move 6 months down in development and planning if you knew all along that this proposal or initiative had weaknesses or was not viable locally. So please continue to be courageous in our conversations, and I look forward to continuing them today. Before I pass it off to Vera, you have the agendas on your desk, as well as Vera's presentation. Once we get to additional material, we'll pass out additional documents. So we'll start out having Vera reorient us to the process, and then they're going to go through the findings from the focus groups that they conducted with incarcerated individuals in the jail during their last site visit. And then they're going to turn it back over to me, and I will walk us through the work that our various committees have been doing since our last task force meeting. So that will be the bulk of the meeting, and then we're going to have some time for conversations and discussion as a group to decide which of the recommendations that have been developed by our committees are something worth pursuing and continuing to develop. And then, of course, some time reserved at the end for public comment. So I'm going to turn it over to Vera to talk through the process, and then we'll switch over to your slides.
Good morning, everyone. I'm Caitlin Call. It's really nice to see you. So real quickly, just a quick overview about where we've gone and where we're going. We see this work taking place in 3 phases. One being qualitative and quantitative data gathering, and that includes a couple different activities, including these task force meetings, town halls. We've had 4 town halls where members of the public have attended across all 4 of them. It's been hundreds and hundreds of people who have come. We've met with jail staff to get their perspective. I want to thank Director Sparber for helping us make that happen. And then, as I'm going to report out on today, we did 4 focus groups with folks who are currently incarcerated in the jail. Another phase of this, which you are all working on right now, is data sharing, collection and analysis, asking hard questions and working hard to find the answers to those questions. There's going to be an additional forecasting process that's by our partners at JFK Institute, and that's where they look at the jail population long term and think where you may be going, where you should be going. And then the 3rd step is developing and finalizing recommendations. Any questions, comments about that? I'm going to switch slides real quick. I know it's going to be a little hard to see, so you should have a handout. Does everyone have a PowerPoint in front of them? Okay, excellent. So on August 1st, me and 3 of my colleagues, Liz, Alex, and Chris, who's not here today, conducted 4 listening sessions within the 2 jails, Geiger and the downtown jail. Before I get into that, I really want to say a sincere thank you to Director Sparber for helping us make that happen. We really appreciate what you and your staff did to enable us to do that. I also want to thank Maggie, who literally went cell to cell for hours to recruit folks for coming. That's no easy task, so thank you for doing that. And I want to thank the people who contributed. They took their time to share their thoughts with us downtown. They opted into this as what they've chosen to do with their day instead of taking out of cell time, so we're really grateful to them. And so through this process, we talked to 12 men at Geiger, 6 men and 4 women in one group at Geiger, and then downtown had 2 separate groups of 12 men and 12 women. We asked a structured set of questions, and I'm here to report out on those. As I said earlier, as part of this process, we've talked to people who work in the jail, we've done interviews with community task force members, we've heard from community members. This is certainly all part of that fact-finding process. And so the reason why it's coming a little later is because Vera has very intense IRB policies when we're interviewing people who are currently incarcerated. So that just took us a little longer, but I don't mean to imply that this data is separate. I think it's all part of the whole. So before I jump in, I do want to say that we know that there are many good people who work in the system who value equity and human dignity. We also know that this is a huge system with a lot of volume and sometimes a lack of resources of dealing with that volume. And so I want to acknowledge that, and I also want to acknowledge that I think many of the participants also understood that as well. There is a lot of alignment in what's in here and what Maggie is going to report out on the suggestions and recommendations you're developing. You might hear things that you don't agree with. I would ask that you listen with a perspective that even if one of these findings or opinions might be factually wrong, it is how folks are feeling, and I think that's a source of data unto itself, right? Like, as we strive towards procedural justice, the way people think about the system, if they feel like they're treated fairly, if they feel like they understand the system they're moving through, we know we get better results. So just keep an open mind. And I'm happy to answer clarifying questions as I go through, but then at the end, I'm hoping we can save a little bit of time to hear what stood out to you, and any thoughts and impressions. So, overview, we asked folks about the local criminal justice system in addition to their thoughts about jail facilities and the future of the jail. So the presentation is broken down in that way, and so I was just going to kind of start at the beginning. Thoughts on law enforcement and policing. People said that police are often not trauma-informed. People felt like police could be aggressive upon arrest, especially if they have a conviction history. And rightly or wrongly, there was kind of this notion that police are driven by arrest quotas, that there are internal policies that incentivize arrest. Moving on to bail and pretrial release. As you all know, many of the people in local jail have been in other criminal justice systems before, and they might even have active cases in those systems. And people felt like compared to other systems, bond was used at a higher amount, rates were higher, and there was less use of OR. And people said that bond amounts were often unaffordable. And I should say that everything in the italics is a quote or a direct quote. This person said the quotes are supposed to set bail at amounts that we can afford, but they don't do that, especially for repeat offenders. And then even if a defendant has the funds to post bond, people talked about it being really logistically challenging to get access to that money. So this man said, I was living in housing for homeless veterans when I was arrested on a no contact order. I was set a $5,000 bond. I had the funds to pay it, but I couldn't get a hold of anyone who was able to access this money for me. So it took him a couple of weeks of being in jail in order to get that money. And people acknowledge that their prior FTAs, even if they're very old, drive up bond amounts, and there's kind of a sense of frustration that something so far in the past was keeping them in jail now. And kind of the impact of unaffordable bonds. Someone said, we're pretrial. When we are held in jail, it's like serving a sentence without having been sentenced. And this next quote, I think there's so much here to unpack. This man said, if we were out pretrial, we would be offered better deals. Many plea to time served. When people bond out or are OR'd, they can fight their cases longer. You can still go to work, go to school, be productive. The courts take that into consideration for your sentence. If you're out and you go to court, you appear to be a normal person. When you go to court from jail, it's assumed that we're terrible criminals. There's a lot in here, but I do want to point out that research really backs up many of these sentiments. We know that people who are in jail pre-trial sometimes do flee just to out is to speed up case processing. People who are out in the community may be willing to take their cases to court. Also, clearly, when people are out in the community, they can maintain employment and pro-social connections. And then there's also differences when defendants go to court. If they're out in the community, they can show that they have a job, they're wearing their regular clothes, versus someone who comes to the court hearing from jail in a uniform, potentially in shackles, etc. So we know that FTA, failure to appear, is a big topic in here and is frustrating to many people who work in the system. So we asked people for these reasons. Why aren't people coming to court sometimes? And here's what people said. People forget. Lack of bus passes and public transportation options. Someone said that they were in a shelter for veterans and that it was pretty far away from court. We all know that with multiple courts, this can be confusing for people. There are multiple court dates, multiple locations, and then sometimes people also have charges in other counties, making it complicated to get to court. Continuances and lengthy case processing times were cited. We certainly know that this is true in the research driving up FTA. Distrust of the system. Someone said, I know I should go to court, but every time I go, something really awful happens to me. So kind of a fear of going to court. Substance use, people who are active in their addiction may struggle to get to court. And then lack of ability to reschedule a court date in an event, something like a hospitalization. And someone told a story about having pneumonia and not being in the hospital and not knowing how to reschedule his court date. So moving forward, we asked people about their experiences with public defense. By and large, people felt like the offices are understaffed and under-resourced. Many people acknowledge that public defenders have high caseloads. This person said, there are not enough public defenders. When there's no public defender assigned, there are continuances and people stay in jail even longer. This other person said, I've been in jail a year and a half, and I'm on my 4th public defender. Some people did speak highly of their attorneys. Someone said, I'm blessed this time with a good public defender. Another man said, I was assigned counsel for the defense, and they were awesome. They came out swinging to defend me. But others really spoke about the difficulties they face communicating with their attorneys from jail, I think especially downtown. Hard to use the phone, hard to get a hold of people, and feeling very frustrated by this, and not really clear on what's happening in their case. And I thought this was really interesting. Amanda Geiger shared this with us, an interest in a more holistic defense model. He said, when I was under federal pretrial supervision, I was given a social worker as part of public defense. And the social worker said to him, I'm here to help you with what you need to stay on the right path. He picked me up and gave me rides to interviews, buying me a cup of coffee on the way. His only job was to help me, and I felt like he really cared. What would it take to get social workers in public defense offices here? Is this something you can find? This is very quiet. Okay, you're good. Okay, cool. Okay, we got the social worker. Okay, cool. We got one thumb back. So moving on to charging, people had a lot to say about charging. And again, a lot of the participants had experienced the criminal justice system in other locations and felt like charging practices may be different or harsher here. Someone said, in other counties, I was charged my charge and I could fight it. But here they overcharge you and then you plead to the original charge, and it's turning everyone into felons. There was the feeling that many cases are charged as felonies when they could be charged as misdemeanors. And then people spoke about the way additional charges impact their case, and they said that charges are driving up bail amounts and slowing down case processing. And this woman said, if I had my bonds at my original charge, I could have afforded it. But they piled on 13 bogus charges. I had to figure out how to bond out on all of those charges, even though those charges were eventually dropped. Okay, and people had a lot to say about plea deals, which is no surprise because we know nationally the vast majority of cases are concluded via plea. So of course people had a lot of experience with this. But people did say that they felt coerced into taking plea deals. Couple quotes here. Even when we're innocent, public defenders try to get us to sign plea deals. I felt forced not to go to trial. They said that they would give me more charges if I took my case to trial. Someone said if you get arrested on one charge, then they add 4 to 5 other charges. If you took your case to trial, those charges would be dropped, that they use them to scare you into taking a plea. And then there's also an interplay between pretrial incarceration and plea deals. Someone said, I took a plea on something I didn't do just because I wanted to get out of county. And someone else said, everyone is taking plea deals, which keeps people in the system. If everyone went to trial, they couldn't keep us all in jail. Okay, moving on a little deeper into this system, we asked people about their experiences on probation. No news, it's probably not news to you, but revocations for violations as a driver of jail admissions. Someone said you can go to jail after your first dirty UA, a urinalysis test, which isn't realistic for an addict. If you get put on probation and miss one appointment, you can end up going to jail many times for the same crime. 6 months of probation can turn into a 3-year sentence. So the idea that probation or violations of probation might be causing some people to cycle in and out. And then people also talked about conditions being burdensome. Supervision fees can be expensive. People discussed struggling to pay for those. Mandated classes can be expensive and difficult to get to. Again, the man who's a veteran living in veterans homes, he really couldn't get to the classes he was mandated to go to. Of course, here in Spokane, you can be supervised by 2 different offices. People talked about that. I mean, 2 different officers, 2 different sets of requirements, 2 different courts. And the idea that if you mess up in one office, you can get punished in the other as well. And then again, this is backed up by research. Conditions of probation can interfere with pro-social activities or the obligations people have to their families. This man said, what employer will let you leave work 3 times a week to go to probation appointments? And so given this, people had a desire to see the culture of probation shift to a more of a case management supportive model. Here are 2 quotes showing that. Probation isn't working, it's hurting. It's not helping people get back on track. They tell you what you need to do, but they don't offer help to get what you need in the community in order to do that. So the idea that there are a lot of requirements, but very little assistance. Sometimes those requirements might not be realistic. And also probation needs more resources. They should have people helping you find jobs and housing, go out there with you. They should have bus passes to your probation office because people need transportation assistance. So in terms of re-entry, I don't think any of these things are surprising. We asked people about their needs. Here are the 3 big ones. The biggest one by far was transitional housing. People spoke over and over and over again about not knowing where they're going to go when they get out and all of the consequences of that. They also talked about how difficult it is to try to access resources in the community. People said, I know there are nonprofits in this community, but how am I supposed to access them if I don't have a place to live, I don't have a phone, I don't have internet? So really that pivotal time. So this person said, you're out in the street when you're released. I was released without shoes in the middle of the winter and couldn't go home. I had to check myself into veteran psych ward just to have a safe place to stay. People also talked about wanting help finding with employment and obtaining social security cards and identifications. And then some people spoke about how lack of reentry assistance really contributes to their recidivism. This person said, I was arrested in the summer and released in the middle of winter in shorts and sneakers that were 2 sizes too small. I had to walk hours with no phone and no money. I stayed in jail to fight my case. I wanted to do good when I got out, but I had nothing and I felt helpless. I eventually found a place I could stay if I offered the person a small amount of drugs, and having a gun made me feel safer. So again, lack of reentry assistance potentially contributing to recidivism. So next, we're going to turn towards people's thoughts about jail facilities, future facilities. I'm going to stop. I just said a lot. There's a lot to digest. Temperature check. How are we doing? Any thoughts? Anything surprising?
Not surprising at all.
Not surprising at all. Okay.
I think it's interesting in light of the work that municipal court has already undertaken and district court is sort of following in their molds in terms of probation and trying to move toward a case management service model. So I would be interested to see what a focus group might say after there's some time to implement that new model. And we'll talk a little bit about the new model later today, Judge Staub, if you want to add anything now or as as we move through the agenda.
Just that, yeah, we're moving towards a new probation model that really is this case management plan. We do have several grants. Ideas 42, which is funded by the Arnold Foundation, is going to be studying our data. So the really nice thing about this is that they're looking at our data now to determine what causes violations, and then they'll be able to look at our data after we implement the new program, and as we move along, be able to guide us, tell us what's working and what's not. So it'll be like very real-time data collection and correction. And when they talk about evidence-based practices, we're going to be it. We're the evidence. They're looking at us to study what works and what doesn't. So we're really excited about moving forward.
And does it include funds for things like bus passes and getting people's social security?
No, it does not. But we're looking into finding that information. You know, we're community court. So we have those connections, and it does include connection with resources as far as, you know, where are these resources? So when a person goes in and talk to their probation officer, so I'm struggling with transportation, the probation officer can at least direct them to the right resources and stuff. So a big part of it is probation officers are going to be considered more as social workers, and really helping the person not only set their own personal goals, but figure out how it is to comply with the court orders and get through all of this. So it will require more regular meetings with probation, but the hope and the goal is that minor violations will be handled by the probation officer. They will be coming back to court every time they have a dirty UA. And it's only when there's a major violation or, you know, an absconding or a new criminal charge or something like that that they're going to be brought back to court. So.
Yeah.
Can you, I have a couple questions on the individuals that you talked to. It doesn't really indicate here if they were all pre-adjudication, if some were serving convictions, were they felony convictions, misdemeanor in municipal, misdemeanor in district court.
Yeah, good question. There was definitely a mix of folks that were pretrial and sentenced. A couple people in federal holds. Okay. No. Okay.
No.
I'm grabbing myself. Okay. Majority pretrial. Some folks with mental health flags. We were not able to keep the participants safe to ask detailed questions about their court cases and what courts we didn't want people to talk about any compromising information. So we didn't allow people to get far into their cases. Anything to add about who's in the room?
No, I think we try to, as much as possible, get a representative sample, but so including pretrial, sentence, across the different courts. But as Caitlin said, we didn't want to get too much into types of cases because that could cause people to identify themselves, and so for their own confidentiality and protection, we had to be careful about that.
Did you do anything, if there were victim crimes, to talk to the victims about how they felt the system was protecting them?
We have not done focus groups with victims. That's certainly something that could happen in the future. Given our timeline, we weren't able to do that up to this point, but that's certainly something that could happen.
And we have started those conversations with Erin at Lutheran Community Services, so that is something, Kelly, that's on our radar.
Thank you.
Yeah.
Yeah, just a point of clarification. We have boxes and boxes of indigent clothing, so no inmates get out with shorts and a t-shirt, so in the middle of winter, just let you know that.
Thank you. And this could have been a long time ago too. I don't know where that timeline was, but thank you. Yeah.
Did any of them say that they had committed a crime and they thought they were being held accountable and that was the appropriate thing?
I mean, certainly people said, like, there are very few people, I don't think anyone said I'm innocent. You know, I think people talked about, a lot of people said, I agree with my original charge and I know I did it. People struggled with feeling like there were additional charges that were backlogging things. So in that way, I do think people were clear in saying, I did this. I don't know if people felt like, is incarceration accountability? Like, I think sometimes those are two different things. I think often in our criminal justice system, it feels like incarceration is the only way of keeping people accountable. Is that what that feels like to the user, to the person in the system? I don't know. I mean, we didn't ask people if they felt like the punishment was appropriate, but certainly people were willing to share that they felt like they had done behavior that was, you know, worthy of being charged. If that makes sense. Does that answer your question?
Yeah, it does, yeah.
Okay.
Thank you.
I would just add, I think there was definitely a sense of responsibility and accountability. I think the theme that kind of came out and what Caitlin is sharing is that sometimes the process can be punishment on top of punishment. So on top of the time in jail, you know, the system not necessarily being responsive to that particular person's needs can draw out the process, for example, and with long case processing times, and then as Caitlin was talking about with the conditions, sometimes not being responsive and interrupting some of the positive things that are happening in people's lives. So it's, I think that kind of punishment on top of punishment, if that makes sense.
So now I'm just gonna want to make a statement too, because I came in at some piece of that, but what I heard is stuff that has been the conversation about incarceration for a long period of time and the way that the system actually operates, and the manifestations of that operation, which is basically that there are all of these additional incentives to go ahead and move to whatever it is that the system wants them to move to as far as a charge. Right, so there's 2 or 3 or 4 additional, like if you don't do this, this is what's gonna happen to you. And I heard that very clearly just in the few minutes that I was here. So that was absolutely my experience in incarceration. And the conversations that continue to happen, including this one now, just continue to affirm and confirm that is a theme that's going on. Now what that says, we've got to figure that out, but it says it.
Yeah, I'll just close the loop on that. I think there's also the sentiment that there is jail incarceration as the punishment, and that is like if you're sentenced, and that was like a defined amount of time, but then all the collateral consequences that eke out of that can last a really, really long time, were really hard for people, and it was really hard for people to get back on track after that. So I'm gonna keep going. We asked folks about their experiences of the jail that they were in, and I've broken it down between Geiger and downtown. So downtown, people felt like jail is understaffed, and that has a lot of consequences for folks. Lack of cultural competency, especially about Native American heritage. We did not specifically ask this question, but multiple Native American participants said a couple things like, officers don't quite understand our culture, they don't quite know how to communicate with people from my background, and lack of services and programming specifically for Native American folks. So this really came up in both facilities. People said that there's some good correctional officers who work in the system, and some officers that if you're respectful, they give respect back, and that is felt positive about that. People talked about a slow response to medical requests, and that was the same with the Geiger. And the feeling that staff needed training on sensitivity and communication, that tensions would be eased if there was better training about how to communicate with folks. And then downtown, people talked about how tough visitation is for loved ones who work 9 to 5. They're unable to visit, and the lack of weekend visits, and also understanding that this is connected to understaffing. So Geiger was a really different feel and a really different experience there. This person said there's little lockup time in Geiger, and there isn't much to complain about here, but it's the legal system that's the problem. So thinking about the system, not the facility itself. People talked a lot about programming, and I'm gonna hear our examples of the programs people liked. There's also the sentiment that programming is less than it used to be, and it's been disappearing, and people don't know why. So here is what people liked at Geiger. They said gardening and community service offered through work release was positive. One person said breaking barriers and financial peace are awesome programs. This man said classes here really helped, but they took away a lot of programs, and we don't know why. I got a lot out of anger and stress management and employment classes. A man in my group said that intensive outpatient program for addiction helped him get sober, and he said, I think it will truly better my life, and he didn't think he would have been able to get sober without it. And someone suggested programs for veterans who have PTSD. So we asked, people also brought up a lot about mental health care. People cited the lack of mental health staff at Geiger. And then downtown, people struggled with the format in which mental health care is delivered. Multiple people said this, I can't talk to my therapist because it's down in the cell and the officer is right there. Someone said it's not therapy session to talk on the balcony for 5 minutes. People did talk about the trauma of witnessing deaths in the jail, which, that brought up a lot for people. The need for more medical equipment and medical staff. And then the desire for more group sessions. This happened in the listening session with women at Geiger, talking about just an hour to connect with each other and to talk about what's going on. They felt like the tension had already eased, right? So people who talk about, especially for folks who are in cells on lockdown for 3 hours a day, the desire to have a little breathing room and be with community or discussion is really helpful for mental health. Even if it was just something like, we are not clinicians, it was not a mental health group, but just a chance to communicate with each other.
Hey Les,
Yeah.
I'm sorry. Was this for East, this conversation, or was it a different, on all fours?
All fours.
All fours?
Yep.
Okay.
So almost done, a few more slides. The impacts of incarceration, no surprise to you, people said I lost my housing, my job, and my family. People talk about the increasing debt burdens that they're facing while incarcerated, including student loans and LFOs. This person thought that this debt might fail her and push her back into crime. And a loss of contact with kids, the fact that visits are logistically difficult for families. People talk about pretrial detention making it hard to research their legal cases and locate evidence to support their case. People don't have the internet, it's hard to communicate. This person said I could be working on my legal case if I was out right now. And then this last quote, this sentiment was really popular. There are a lot of nonprofits in the community to help us, but we have to be out of jail in order to use them. So moving forward, we asked people about their ideas for improving the system. So ideas for improvement within jails. Someone asked for a list of community resources and pods with up-to-date phone numbers. They felt like something like that had existed, but all the numbers are out of date. That'd be really helpful. The desire for outdoor space with fresh air and grass. Someone at Geiger said even being allowed to sit down in the grass would be a nice reprieve. People asked for a lot of different types of classes and programs, including access fees for folks who are held pre-trial. People really asked for the opportunity to demonstrate that they are setting goals and that they have a desire to improve their lives. Like that was a common frustration is, I want to change, I want to prove that I can do better, but I can't figure out what that pathway is. And so these are the programs that people suggested. AA, NA, anger management, computer skills, GED, skill building, resume writing, weekly religious services, and programs for veterans. Someone suggested an on-site office for the Mail Project, increasing staffing to enable more out-of-cell time, including on weekends, downtown, and then expanding work release program and eligibility. People really spoke favorably of work release, but felt like sometimes it was a little hard to figure out who was allowed into it, or maybe it was like a little arbitrary, just wanting that to be a little easier to get into. Ideas for improving community-based services. People said homeless shelters are almost always full. So many of the people in these focus groups had been homeless or were homeless. And there was a frustration about seeing money put towards things like enforcement or like deterrence. People talked about like structures being built to discourage homeless people from hanging out, but like that money should be put into affordable housing and homeless services. This person said resources exist in the community, but you need to be able to get to them. People should be given stable housing for a few weeks so that you can get to the resources you need. There are a lot of people here who want better lives, but we aren't provided services to access the services that we need, and they have no chance. And this came from a Native American participant who said, invest in clean and sober homes operated by Native tribes, support culturally competent NA and AA programs. He even suggested a nationally recognized TA provider called White Bison to help with that. So I'm crossing that out. He had done his research.
I just want to say, I'm County Lodge Community Practice. Be mindful that there are no Native American or African American mental health facilities or drug treatment programs in Spokane. We keep talking around that issue, but that is a core of our disproportionate. We operate it for kids, Student Lodge operates it for kids, we're talking about adults. We have
So ideas about system-based reform. Establishing inpatient drug treatment options for people pre-trial, not necessarily in the jail, but people in a moment of crisis wanting help getting sober. And different options for people booked on simple possession. Our data shows that there are many of those folks in jail, and people certainly were aware of that. Someone tossed out the idea of reducing simple possession from a felony to a misdemeanor charge. A desire to see more money invested and resources invested in pretrial services. Shifting to a system that presumes innocence during the pretrial stage. A lot felt like, said, I don't really feel like this system is operating like innocent until proven guilty. Establishing jail alternatives for mental illness. Not only, people also talked about kind of the harm and the trauma of seeing people with their fellow incarcerated folks with mental illness struggling in the facility, that it creates disruptions, that's really difficult, and just jail not being a good option for those folks. Again, rethinking the criminalization of homelessness. A lot of people felt like their homelessness contributed to their involvement in jail, feeling a little harassed. Increasing funding and number of public defenders. Rethinking charging practices. Providing more oversight of law enforcement and correctional officers. And then, as we talked about earlier, shifting probation to a case management model. And for the last slide, we asked people what they thought about the future of Spokane jail facilities. Some people thought build a new, more spacious jail. Others said, I don't think that they should put money into bigger jail. The system will repeat the same mistakes. And similarly, the solution is not to build a bigger jail. Instead, we should use those millions of dollars to hire more public defenders and judges. The main disease of the system is that cases last way too long, and a bigger jail would only increase this. And then finally, again, the idea of investing in infrastructure and services to serve as jail alternatives for folks with mental illness. So that concludes these slides. How are we doing on time? Good, okay. Questions, comments, anything that stood out to you? Anything that felt like a big aha moment, a surprise, in keeping with what you already know?
So I had a question, if you don't mind. So I think that third bullet on the last slide, I can't remember, it seems to me that it's been too long, but we do have an extra long compared to other communities, do we not, in terms of time in incarceration under pretrial and that? Is that an accurate statement, I guess is what I'm asking?
First, let me clarify, make sure we're on the right.
Yeah.
Are you talking about this bullet point? The solution on the screen?
Yeah, it says the solution is not a bigger jail.
Yeah, about case processing.
And you talked about the disease, the system, and cases take way too long.
Yeah.
But my question is that an accurate statement? Because it seems to me like it is.
I think that's true. I mean, most jurisdictions struggle with this, but certainly, and I think that's been identified by the benches here, and there has been some earnest interest, and I don't know if anyone from the bench wants to talk about their work with NCSC or case processing. What else?
I know that we're in the process of trying to develop a case management system that's similar to the one that Spirit Court's already implemented. And the hope and the goal is to watch the time to disposition and then start shortening that up as people get used to a new way of handling the cases and stuff. But, anytime you move to a new system, it creates issues. And so we are working out some of those issues and stuff. But it's definitely something we're looking at and moving toward.
Yeah, that's great. I think there are many good reasons and many positive benefits of case processing reform. I mean, certainly there could be a downside if people take it too far and cases move too fast and it doesn't feel like a meaningful experience and people don't get the representation that they deserve. But many of the jurisdictions that have reduced their jail population significantly is attributed to case processing reforms. It's folks who have just stayed there too long and their cases are taking too long. I think it's also a procedural justice thing. I think having meaningful court hearings that move along and move forward, how both defendants and victims feel respected and like the system is responsive to them. So I think, so I totally second this person's sentiments, and I'm glad to see that this is something Spokane's working on.
And for folks who don't know, Spokane has partnered with the National Center for State Courts to provide technical assistance support for municipal court and district court through funding through the Safety and Justice Challenge funded by the MacArthur Foundation. Citation. The National Center for State Courts previously worked with Superior Court and helped develop reported recommendations that Superior Court has been working to implement, and they're going through the same process with municipal and district courts now. Okay, so we're gonna take a quick 5-6 minute break so that people can stretch their legs. The coffee is ready in the focus groups, and for summarizing them for us. As Caitlin mentioned, I was really struck by when I reviewed the focus group material or the findings that were summarized that so many of the sentiments that were included there are tracked in our committees as well. So people impacted by the system and people working in the system have a lot of shared insights and shared recommendations. So that's, I think, heartening that we're all thinking about these issues the same way and suggesting similar solutions. So as you know, since our last task force meeting, we have broken into 3 committees: the Cost Committee, Community Collaboration, and Rethinking Incarceration. These committees have each been staffed by law students at Gonzaga, so big thanks to them. They couldn't be here today because they have class, but they've done a lot of research for us that have informed our conversations. The rosters to these committees are online, so if you're not sure which one you were supposed to be at, please take a look or send me an email. And then we're going to continue meeting for the next month or so to finalize some of the recommendations. We have been meeting weekly. I would estimate conservatively that based on everything we've done to support those meetings, we've poured another 200 hours of meetings, discussions, and research into these committees. So there's a lot of rich data that we're going and information that we're going to be moving through. Please feel free to stop me with questions, but we can also chat at the end of the presentation as well. A shout out to our Rethinking Incarceration Committee, who probably had the best attendance of all 3 committees and had their meeting scheduled at 8 a.m. on Monday mornings.
That's right.
Each of the committees followed similar phases. First was looking at target populations, then we moved into targeted investigations and research, and then finally we are now developing targeted recommendations. Some of those recommendations are going to be shared today, and the goal is for us to have a conversation about those, decide what we can collectively endorse, and then ultimately we'll pass those on to our Board of County Commissioners for their consideration. And before actually we move through these phases, just a reminder, as Vera mentioned, JFA is still doing our forecasting. They're working on looking at what our jail population could look like in the future. And just remember, they're going to provide multiple different possibilities. So they're going to look at if we did nothing and continued practicing business as usual, what our jail population would look like. And then if we implemented various different policies and initiatives, how that will affect our population. So they're going to take our recommendations that we endorse as this committee and calculate those into their forecasting models as well, so we can see how this will impact our jail population in the future. Our target populations were really informed by JFA's data analysis that was done related to our jail population at our last meeting. Before we get into the target populations with the data though, I want to discuss the tension that was revealed in conversations talking about our jail population and trying to identify our target populations. And that's this tension between theories of punishment and the function of our jail. So we talk about in our committees a lot in terms of holding people accountable. You've heard that here this morning. We've talked a bit about incapacitation, especially with domestic violence or property crime. And then we also talk about rehabilitation quite a bit in our community. These are theories of punishment that we, at least it sounds like based on our conversations, value. But that is not necessarily the same thing as how a jail should and is being used. So to remind ourselves, our jail is predominantly pretrial. 70% of our population, as we'll discuss, are pretrial. So those individuals have not yet been convicted, and they're still presumed innocent. And one of our judges on our committee said eloquently that holding someone accountable at a pretrial hearing is not appropriate because they're still innocent. So really the question is not what sort of theory of punishment do we want to make sure we insert in our jail, but who should we be incarcerating to maintain and increase public safety? And on the flip side, who should we be releasing back to our community to maintain and increase public safety? Because as you heard Caitlin mention in terms of research, we know that pretrial detention actually can have adverse consequences for our levels of public safety. It disrupts people's ability to take care of their family, it disrupts employment, treatment, accessing a whole host of resources. We also know that folks who are held pretrial simply because they cannot afford their bail actually have an increased likelihood of committing new criminal activity and an increased likelihood of unemployment in the future. So again, this is just framing our conversation of the targeted populations. Who should we be holding and who should we be releasing? Fortunately, we do have state guidance that informs this distinction, or limitations depending on how you look at it. But we have Court Rule 3.2. And there are a lot of practitioners and experts in this room, so feel free to provide additional details and nuances. But for folks who don't work in the criminal justice system, this court rule mandates that judicial officials release people pretrial, unless a couple of different risks are present. One, a failure to appear for court, or a failure of committing violence during release, or obstructing justice, interfering with witnesses, that sort of thing. And even when those risks are present, judges have a whole variety of conditions that they can impose to make sure that folks are released with the least restrictive conditions, which doesn't include jail necessarily, and they can show back up to court safely without committing any new violent acts. A couple of these conditions include supervised release. They also can include bond, and bonds can be unsecured, meaning someone pays if they don't show up to jail. They don't have to put cash down to get out of jail. And it can also include secured bond that they have to pay in order to get out of jail. If a judicial officer decides that bond is the most reasonable and going to be the best condition to impose, then we need to make sure that they need to make sure that there's a financial assessment, someone's ability to pay. Because we don't want to have a system that is holding people pretrial simply because they can't afford bail, where other people who can't afford that bail and might have very similar backgrounds or similar charges put the money down and are released. So again, this is just sort of framing the philosophical debate that we're having to have as a community and the legal framework within which we're having. Moving on to the actual data, these are the target populations that our committees identified through our jail population. First is failure to appear. We know, and we have known anecdotally for quite some time, that our failure to appear rates are very challenging and they're a huge issue. Judge Smith was sharing the other day that on his arraignment docket, 70% of his docket didn't show up to court. And that's consistent. And it's consistent with the data. 17% of all of our jail bookings are for a failure to appear. 24% of all of our releases are solely for a failure to appear. And these populations are staying roughly 8 days in our jail simply for a failure to appear. So we'll see this come up again and again in the data, and part of what our committees looked at was, are there other ways we can be using our resources that are currently being devoted to holding these people in jail for roughly 8 days, to getting them back in the community, stable, and coming to court successfully and with stability? Yes, Judge?
So do these include the book and releases?
Yes.
Yeah, they
So
do.
if those are taken out, those statistics are going to be dramatically different.
But it does include, as you see, the length of stay is roughly 8 days.
But,
So-
right, but a huge chunk of those are 1 day, because technically 1 day,
That's
they're not
exactly right.
releases, that's what I'm saying.
Yep.
Those aren't even
Yep.
put in detention, they're just,
Yeah, these are our averages. So Diane, I don't know if you want to speak to any of the details about this data poll that you did.
So that's all of the bookings. There is another slide later for all just the
Yeah,
OR
I know.
ones that you
Yeah,
can
so
look
we'll
into.
see that in a bit, just the ORs. That includes new charges for book and releases and our warrants for book and releases, which was a request that came out of our last committee meeting. Yes, Rena?
Do we have an actual number of what the appearance rate in Spokane is overall? or
We,
in each court?
a lot of the reforms that we started implementing were done before our baseline was sort of calculated, so we don't have that as far as I'm aware. I don't know if our judges around the room know of anything. So no. Okay. Next target population population is failure to comply. So you heard Caitlin talk about probation violations and the conditions of probation. Again, for folks who aren't familiar, if you're sentenced to probation, you're released with a list of rules that you have to follow. And in isolation, those rules might make sense and might be reasonable and doable. But in the aggregate, they can be incredibly burdensome. And if you break one of those rules, you can end up back in court for failure to comply, a probation violation. This is a smaller percentage of our average daily population, but we see that they stay for a really long time, roughly 20 days in jail, even though they only make up 4% of our average daily population. So a small percentage, but long length of stay. Thinking back to our coffee shop analogy that Caitlin shared with us during our first meeting, it's not just the beds that are eaten up, but how long they are eaten up that really informs our jail population. We talked about our behavioral health population in our last meeting. Recall that just about 60% of all of the bookings into the jail in 2018 had received behavioral health treatment prior to that incarceration. This is a conservative estimate because it was only looking at behavioral health agencies, so it didn't include other service providers like primary care physicians. So this number is likely even higher. And we also know that 21% of individuals in our jail are facing the highest charge of a possession of a controlled substance, a drug-related charge, which often can have a connection to substance use and addiction. Remember that the highest charge is a hierarchy, so they could be facing additional charges, but the highest one is a possession of a controlled substance. Contract beds is something that we've had a lot of robust conversations about, and we're going to have, hopefully the U.S. Marshals come to an upcoming Spokane Regional Law and Justice Council meeting to talk about the needs from their perspective, the numbers that we have in our jail, etc. But it is something for us to think about and continue to talk about. We charge $84 per day for our contract agencies per person, whereas our other billing agencies are charged $134. So that includes the city of Spokane and the city of the Valley. They're paying $134 per day. Our contract population is roughly, 16% of our average daily population. So they're eating up a lot of beds. They also tend to stay long, especially our U.S. Marshals are in there for quite some time. And we're also seeing some of our racial disparities being introduced to the system with our contract beds. 59% of our Hispanic population is brought in by a law enforcement agency that is not a local law enforcement agency, state or federal. So there are a lot of arguments pro and con for our contract beds, including the fact that many of them are facing local charges that allows them to stay in contact with their families. It allows them quick access to court and to their public defenders. But then there's also obviously challenges that come along with that. Yeah, Judge?
So on the first one, it says 40% of the beds are in the jail right now are City of Spokane?
Admitting agency.
So if the city police, if the police bring them in on a felony, you're still counting that as a city, even though it's the county.
Admitting agency, but not billing agency.
Okay.
Yeah.
Okay, good check.
Yep. Teresa's appreciates the clarification, I'm sure.
I'm on the right slide there.
Moving on to our sentence population, 17% of our jail is sentenced. So those are folks who are sentenced to a year or less who can serve that sentence locally. But this percentage also actually captures people who've been sentenced to DOC and are still awaiting transport to a state facility. So the local sentences might be a little bit lower than this. Multiple charges. We heard some from our focus groups about charging practices. We also, as you recall, had this information at our last, or at least some of this information at our last meeting, that folks coming into jail are charged on average with 4.2 charges per person. What we were able to glean since our last meeting is that people being released from jail are released with an average of 2 charges. So there's a difference between what you come into jail with and what you leave with. Now, there are a lot of different explanations for that potentially. One is that if you come into jail with 1 charge, maybe that if you're typically less of a risk to the community, you're more likely to be released. That pulls down the average of our charges at release. It also might implicate evidentiary issues for the case, and it also might get to the challenge of charging practices and upcharging individuals. So It has been used as a negotiation tactic around the country where prosecutors can charge multiple charges to get someone to plead to the 2 charges that they leave jail with. So we don't know what the reason or the explanation is behind this discrepancy, but it is there. Are there any other reasons that folks can think of that I didn't mention that we should also consider in explaining this difference? Yes.
Meg, I just want to go back to the DOC, the upper slide of the DOC. Nope, go back to the other one. On the on that DOC part of that, the folks being held on that DOC is people that are waiting to go to prison, but are on that appeal, that instant appeal process of waiting. And sometimes that can take up to 30 days. And so that adds on to the length of stay. And there's arguments that go back and forth on that. They say that they could go immediately to prison and they could do their appeal process from there. And then there's others that say that they have to do that locally. And so I'd like to get a clarification on that if I could, you know. And I don't know we'll solve it today, but it'd be nice to have the answer to that, so.
Yes, Tom?
I guess I would just say that sometimes it depends on the client.
I think we talked about this, you and, yeah.
Yeah,
Okay.
so a lot of times the client may want to stay local as long as they can and see their family. So, you know, we tend to work with them a little bit on that. And but normally the appellate paperwork can be prepared immediately at the time of sentencing. So sentence, appellate paperwork filed, that can be done.
And done on the shuttle that week, or?
It depends on where the appellate, I mean, when you say appellate process, you have to also consider that, at least in my experience as a prosecutor, sometimes if maybe they've talked to a jury or there's something comes up and they want to challenge the conviction still at the superior court level, which they're entitled to do under a court rule. That's the first step of appeal, and I know sometimes I've experienced that offenders stay after sentencing because at sentencing maybe a motion for new trial is filed that has to be heard. And then there's the appellate process of going to Division III, taking it out of the local superior court and going to the next level of court. So that can be a mixed result as well. And then if you are talking about offenders that have a pre-sentence investigation, those things done, they're gonna stay longer at the from the time of plea to sentencing, because the pre-trial investigation has to be conducted, and that takes at least 40 court days.
Oh, wow. And that needs to be done locally, and?
It's done on certain offenses, mostly sexual-based offenses, and then if there is a concern that somebody's got a mental health issue that maybe wasn't raised or is being considered for what the sentence will include and where they'll go at DOC, they can also have a PSI. I think those are the only 2 left. I would defer to Judge Clark I think it's just those 2, but pre-sentence investigations usually take 40 court days, so business days.
Is that the exception, or I mean, does that happen very often?
Always.
Yeah.
In those types of cases.
I mean, no, I mean, is that, how many of those cases are we thinking, very rarely, or?
It's a small number compared.
Small number, yeah.
It's only those 2 scenarios of sex offenses, and then if there's a mental health issue.
So probably this segment of population is worth looking into, certainly, you know,
That should be
as far as our
fairly
process, yeah.
All
Yeah.
should be fairly small.
Okay, thank you, I appreciate that.
So Liz, I saw you taking notes. We'll just flag that for some data analysis and then also for consideration by one of the appropriate committees, likely Rethinking Incarceration. So you can expect more information on that. Sabrina, you go ahead.
I'm just curious about the sentenced population versus pretrial here on that same slide. Are we including people who have been brought back in for like a show cause hearing in the sentenced population, like for failure to comply? It's basically a probation violation, but they're being held with a new bail as if it wasn't a new charge. So I'm not sure.
Karen, do you know where our failure to comply are captured as pre-trial or sentenced?
Pre-trial.
Thank you. Yes, Teresa?
Since we're on the slide, do we know what the average length of stay is on the sentence?
During the pretrial?
I believe we do. I don't have that information with me. I think we have it broken down by
They
certain
shouldn't be in
charges, so I'll have to double check and make
Oh,
sure I
they
get that
should have
information to you.
sentenced.
Our
Those are
average length of
sentenced.
stay across pretrial and sentence populations is roughly 18 days, but I know that's not getting to your question, so we'll try and get that information. Okay, moving on. We've already talked about this. Our pretrial population eats up the bulk of our beds in jail, 70% of our average daily population. These are folks who have not yet been convicted. As Diane just mentioned, it does include failure to comply, so folks who might be out on probation and are brought back in for evaluation. We also looked at low bonds. So 10% of our population, our average daily population, are held on a bond of $1,000 or less. Yes, sorry.
I apologize, I just meant to ask, do we know on slide 6, multiple charges, do we know if that ratio of average charges to release number is consistent with other jurisdictions, or?
So what we heard from our consultants at JFA last meeting was that they see nationally about 2 charges per person. And so last meeting we only had the 4.2 charge number, and I'll ask JFA to let us know if this is consistent, but they did point that out as something that they saw as pretty significant for us to address.
Maggie?
Yes, Commissioner.
On the multiple charges, did you notice any racial disparity with regard to the charges?
So we see that it's roughly the same across racial groups, the number of charges.
Okay.
Yep.
Okay.
Okay, so low bonds, 10% held on a bond of $1,000 or less. This means ostensibly that they can't afford $100 to pay to a bondsman. Sometimes bondsmen don't like to take that small amount of money, which also can be why they're held, but they don't have $1,000 or $100, or a loved one who can put that money up for them. We also can see now that only 3% of all releases from jail are due to people posting cash bonds. So it's a very small percentage of the releases are related to people who can't afford their bond amount. We see that the 3% release rate based on cash bond is the same roughly across racial groups. However, we see that the amount of bail assessed is different across racial groups. So we broke this out by felony and misdemeanors. Someone who is facing a felony charge who is identified in our data as a Black individual, their bond amount is about $220,000. Someone who's white facing a felony charge, they have an average bond amount of less than $100,000. And we also see disparities in misdemeanors as well across racial groups. So about $7,000 or $6,500 for Black defendants, and I believe it's about $2,500, $3,000 for white defendants facing misdemeanor charges. Yes, Director.
How come our other is so large? Is that self-reported or not?
Sorry?
The other category, is that non-reported, self-reported?
Yep.
Still those
Yeah,
challenges?
it also includes, I believe, our Asian population and then people who are not identified in the
Okay,
data.
we've got to tackle that group. Okay, thank you.
We can't break out the Asian population, but then the folks who are sort of
It's
lost.
just self-reported.
Yeah,
Okay.
and we,
Did you do any, go ahead.
I heard felony bonds for African American range around 220,000.
Yeah, and for white.
65 misdemeanor.
Roughly. So you can see the graphs here, and we have the specific numbers, which are on our previous slide deck from our second meeting.
And this slide deck is going to be available.
Yep, all of these materials will be posted online. Judge Clark, did you have something?
When you said, was it for all felonies, you combine all the felonies together?
Yes.
Come to that figure, okay. Is
So you
there
didn't
data as to is there data as to particular charges?
We do. I don't know that that's in this, but we do have it broken down by charge, I believe.
Was there still a disparity as we went to per charge?
I think so, and we can pull that up during a break, but based on
Okay.
my recollection, there was some disparities. It's hard because we don't have the facts of the case when we're looking at these aggregate numbers, but yep.
That's
But
why I
you
was-
have the charge classification as
Yeah.
to violent or non-violent,
Mhm.
which under 3.2 can affect on
And we see
consideration.
that there are still disparities across the different charges.
Yeah, and Kelly, when you got other, that big a other on there, that makes it really rough. I mean, because those are when they come in the book, it is self-reported. So we've got to nail down that other category, because that's really skewing the number too.
We can get that number from you, the broken down
Yes.
figures, please.
Yeah,
for sure.
and I also think that we can do it by court as well. And you'll see the top, in a later slide, we're gonna have top charges across all 3 courts as well, but we can get the bottom amounts for those as well. Curtis, and then we're gonna move on to the next slide.
Yes, this question is to the judicial officials in the room. How do we justify that much of a disparity between the amounts between 100,000 and 200,000+? How do we justify that? I mean, I'm just struggling with that. So, what goes through your mind to say this is okay?
I think we're asking to have some more information about how they get to that number, because bond is not just driven, I mean, some of it's driven by charge, but it can be driven by criminal history. It can be driven by, is it a felony that's a Class C felony versus a Class A felony? So I think to give you a more blunted answer and to really determine what the issue is, we need some more information on the makeup of the data and analysis.
And I guess just for my standpoint, I'm trying to understand, you know, we talk about accountability. My question to the judges in the room, do you feel that judges are held accountable for their actions as well? Because there should be some type of standard way of charging. And with that much of a gap, if we do not agree with that, then what's the problem in between?
So I can't justify that figure without knowing what the figure is. That's number one. And number two, the state charges, the court just goes through the release process. So again, there's an interesting interplay there. But again, without breaking the data down, I can't justify it. I can't even comment to it. But I would agree with you. It's a concern. That's why I asked the follow-up question, can you give me the data so I can look at it, go back to the bench, and we can break it down and sort it out. I guess the phrase is personal. Then we can figure it out. But beyond that, I'm sorry.
Judge Staub and Sabrina.
Curtis, I agree with you about big fat stars written all over here, because if it's a systemic bias issue or an implicit bias issue, then we need to address it. And we're just now getting to the point where we can pull out this data and look at it. And so this is very surprising to me. And we need to dig down into it and find out what's going on here. Is there something going wrong here? So when you talk about accountability, I agree with you. We need to figure out what's going on and then fix it. So we'll get into this, okay?
Really quickly, Sabrina, before we get to you. Diane, do we have on your laptop that breakout of charges and bond amounts?
I can pull it up. Just be careful. These are based on the highest charge of a person. This person might have high bonds because there's multiple charges in them, and that's not something you can compare. Like a felony, no. That Asian one, for example, is $1 million one. That because the Asian population is small, so that 1 million bond. I don't know what he did, but that 1 million bond increased the average quite highly. So you have to be careful of the size of these population, the highest amount or the maximum amount in each of those population, because that affects the average, and the number of charges in each of those population as well. So some of those might be higher because the number of charges within that population is actually higher in comparison to the other racial groups. So those are all factors in. I can pull all those information and I can give you those, but I'm not sure if, without actually looking at each specific person, if you can actually compare them, because that's not easily comparable. The most I can do is give you like people with one charge, because then that's easy. Like if they all did controlled substance, then you can see like what's the difference. But even then, circumstantial evidences for each of the case would be different, and that would affect the bond that you set for them.
So a lot of different factors feeding into this that are complicated and difficult to sort of simplify for us to just compare, as Diane was saying. Thank you.
Just really quickly, I was curious about how, is there like a graph or something that judges have to say that the bond amount for this charge is in this range? Or do you guys arbitrarily come up with the numbers based on the seriousness of the crime? Or how do you come up with a number in the first place?
All of those factors. We're considering the criminal history, failure to appear rate, the likelihood of dangerousness. I mean, there's allegations in this case that the person has threatened to go back and, you know, kill their partner. You know, all of those things come into play, which is good and bad. It allows us to take individual circumstances into play, but it also allows implicit bias to come into play.
Is there a, like?
Thank you for that.
Thank you for that, yeah, definitely. Is there like something that says the charge of blank has this much money attached to it for a bond?
There is a bond schedule for misdemeanors. It's just $500 for a simple and $1,000 for a gross. But then there's also the rule that says there's a presumption of release.
Right.
So we start with that presumption of release, and then we consider, are these other factors present? And you know, in addition to, what's this person's income? Because if it's not a safety issue, then, you know, the presumption is they should be able to get out. So.
And superiors?
There's no schedule. If you came and looked at first appearances, though, you know, 50 or 60 people a day through first appearance, you would find the bond amounts get very consistent in terms of the charge based on failures to appear, other factors. They're not wildly different. In other words, you're going to find a lot of the bonds between, Tom help me out, $5,000 to $10,000, $15,000 in terms of bond amounts. So very consistent for the bulk of the felonies. The ones that were referred to here that really skew the figures are, all of a sudden you have somebody who's got $1 million bond. That really changes the figure, and that's going to be obviously just one in, I don't know, thousands of cases that come through, or at least. So there's no bond schedule though.
Okay.
Sorry, just to help, I think.
All right, Tom and then Commissioner Kearns, and then we're moving on.
Just to help answer Curtis's question, I think we also need to go back and look at the charge and then disposition based on race.
Yep.
Because if, for example, if there was overcharging going on, that's what a judge is seeing and making a decision on bond. If that makes sense?
Mm-hmm.
So I think we need to also have that put in there.
Great.
So we can see.
If I could just piggyback up what Tom just said. I realize it's one of those-
Curtis is sliding it in there.
You know, we have task force for everything. I'd like to throw on the table if possible, as this is a task force that we're involved in right here. Could we get a task force to oversee the decisions that our judicial systems are making for transparency purposes? Because things that are done under the light, there's more honesty with that as opposed to, and not that anyone's dishonest. I'm just trying to, we need to be more consistent because obviously we're not, and if we're not going to look at why that's happening, because of what I'm suggesting is a way of get to the root cause of this disparity. One way to do that is to show transparency, and if we have a task force as an oversight committee to look at this and somehow post it so we can all see, and there won't be any questions about why a judge decided or a prosecutor decided to do this or that. It'll be obvious.
So as Judge Staub mentioned, this is this is a new initiative in terms of getting this data faster and seeing all sorts of different data points. And as many people around this room know, Diane Lindquist was hired to help us do part of what you're talking about, Curtis, is get more transparent data and get it posted so that our people internally can see the decisions and the outcomes that are happening, and then also the public can see the decisions and the outcomes that are occurring, and we can hold each other accountable from there. This task force, though, also is designated to help us start to digest this information and then start to develop recommendations for how to improve the outcomes based on that data, as well as the qualitative information that we're gathering as well. Thank you, though, for raising that. And just really quickly, Commissioner Kearns, and then we're going to move on to our last target population.
Well, so I cheated and looked a few slides.
Okay, so moving on.
There's always one.
One of the reasons that could be, a reason for this disparity is, like Judge Clark said, if there's $1 million bonds put on an individual, say if it's, when I look here for felony in the snapshot, it's a Native Americans 38. If one individual who's Native American gets $1 million bond, that's going to skew that number so high for that race because it's 38 people. If $1 million bond is placed on somebody who is white, there's 515. So it's spread out over a much larger population in the jail of 515. So you're gonna see a bump, because $1 million is a lot of money, but it's not going to be as dramatic for where there's a smaller raw number of population of folks in the jail. So, I mean, maybe a scatter plot, maybe a better way to look at this.
Sure.
Take out the high end, take out the low end, and kind of look at that median value to get a better idea.
Yeah.
Because when you look at average, when you're looking at a smaller raw number of population, you're gonna get, you have the potential
That's a good point.
to get those large swings like that, because the raw numbers of populations for the races vary so much.
Yep, this is really helpful, thank you. So as I mentioned, this is just a start to our data and some brand new data as well, so it's helpful to sort of workshop some of this, and I appreciate it. Diane is taking notes, so we'll get new information to the group as well.
And that's the same for Lincoln State.
Okay,
too.
so moving on,
It'd be the same way.
almost there, folks, to move on to a new subject.
Oh, your slide just went.
Yeah, that was okay. Oh, you're good. So why we were looking at low bonds to begin with, we sort of realized was getting to the issue of low risk. And we were using bail amounts as a proxy for risk level. And then I realized that we have some other data that we can also use to sort of get at this question. Who are folks who sort of pose an acceptable level of risk that can be managed in different ways in the community? So Judge Staub had asked about book and releases earlier. This next slide gets to our book and release population. 13% of all of our bookings or admissions into the jail are folks who we call book and release. They're folks whose information is taken, they're given a court date, and then they're pushed back onto the street. This causes a lot of frustration for a lot of stakeholders for a lot of different reasons. But it does put a lot of pressure on our booking staff. It's a huge flow of people, as you can see, 13%. This slide also shows you how many charges this population comes in with on the left side of the slide. So about 60% are booked and released only on one charge, excuse me. And you can see the top 10 offenses that folks are booked and released on. The very bottom of that chart, the warrant type, is a request that came out of our Rethinking committee at our last meeting, and thanks to Diane for pulling this together so quickly. It breaks apart our book and releases by folks who are brought into the jail and released on a new charge, and folks who are brought into the jail and released on a warrant. So only 26% of this population are booked and released on a new charge. The majority of them are booked and released on an FTA only, almost 70% of this population. So it's just another data point to see what a huge problem our failure to appear rate continues to be locally. We also can look at our charge breakdown, and this is sort of broken down in line with state guidelines. But if we look at just people who are facing a highest charge of a drug charge, folks who are facing a nonviolent felony, and folks who are facing a misdemeanor, not a gross misdemeanor, that totals 451 people in our jail who face the highest charge, a highest charge that is nonviolent. And then the next slide breaks down our top highest charges by court. This was a request that came out of our last task force. Judges were fairly saying that they can only control the cases that come before them in their court, so they wanted more information about what they were actually seeing. So you can see again, we already knew this our last meeting, that possession of a controlled substance was the highest charge that we're seeing in Superior Court. In District Court, we see a lot of DUI and other driving charges. And in Municipal Court, we're seeing a lot of assault and thefts and violations of protective orders. Is this consistent with folks who practice in these courts with what you're seeing on a day-to-day basis?
These are bookings?
These are folks who are in jail with their highest offenses.
Excluding book and release.
Diane, this excludes book and release, correct?
Includes.
Includes book.
Oh.
Yes, Harry.
How can there be such a discrepancy between district court and municipal court on DUIs, 5% versus 29%?
WSP.
Yep.
State Patrol. That's literally their primary focus, is traffic.
Yeah, and we handle all of those.
Yeah. I think these are pretty consistent with what we see.
Yep.
The assault, majority of those are DV assaults in
Matter of
municipal
fact,
court.
this looks pretty
But
damn good.
Yeah. We file about, I think, around 500 DUIs a year, And Kelly, I don't know what you guys are, but it's a very large number, because WSP, it's not the sheriff's department.
It's at least double
It's,
that.
yeah.
I mean, I can find out from our district court supervisor, but I think it's at least double that would be my guess.
Yeah.
Are city law enforcement still calling in WSP?
Nope.
They stopped doing that.
That's been well over a year. Yeah, because we've received our money from the state that's given us, actually it's been over a year. So, yeah, that is, the outlier isn't really the local law enforcement, it's how the state, and you know, that's their mandate. That's their mandate from on high, from the legislature, and they're funded to do that, and they do a very good job. They're aggressive, and they handle all the calls on I-90, pretty much anywhere. So from border to border on our county, they're going to handle all of those, and all the state highways, as well as a lot of arterial roads they're going to handle as well. So.
In my year posting bails and evaluating people for the bail project, I never actually encountered a person in jail on a municipal court driving under the influence.
City
They're
is-
always in district.
Yeah, city assault is usually what it is,
Huge.
or,
Yeah.
or trespass. Yeah.
That's,
So the next slide also gets into our misdemeanor charges. We can see that, folks, there are 158 people in our jail facing misdemeanor charges. And we looked at how many of those have domestic violence flags, because we know this is a serious issue and a serious concern for municipal and district courts. Only 37 of these cases had domestic violence flags. So this doesn't mean that it's not a significant issue, it's just sort of helping us understand the scope of what we're seeing and the specific population that might need sort of a tailored response. So it shouldn't stop us from thinking about pretrial release or pretrial programming, it's just contextualizing sort of the population for misdemeanors.
A lot of those are tagged on so that they do have a mandatory hold in jail. So, because they know that it'll hold them in jail if they tag on a DV with whatever charge it is. So.
So what Director Sparber is saying is that if you're facing a domestic violence charge, you're not going to be booked and released.
So,
Yes.
just saying.
Commissioner Kearns?
How is the highest charge determined when somebody has, say, 3 of them that are on this list? You know, someone commits an assault, steals somebody's wallet, and they have drugs on it. I mean, you hit 3 things. Like, how do you determine which is the highest?
We broke it down between felony and misdemeanor. So if you're charged with a felony and not a misdemeanor, we're going to count you in the felony hierarchy. Okay. And then those are informed by state sentencing guidelines.
What if somebody has 2, they're booked in on 2 felonies? You know,
Yeah,
say
so then
an assault and possession of controlled substance.
The
Which
state sentencing guidelines breaks it down into certain categories that include, I don't know if we have them here, but there's the violent offenses, the non-violent offenses, sex offenses, things like that. And so that's how we ranked them according to those. And we didn't drill down any further than that, because then it becomes sort of a difference of opinion of what's more serious than another charge.
Can I ask a question about the DV flag and how that gets, who's flagging that, at what point?
It's up to the law enforcement. It's out there at the time.
And what earns a DV flag?
Pardon?
I mean, does it have to be an intimate partner? Can it be your child or your grandparent, you know, your mom or dad?
I think it's all the above.
yeah,
Isn't it?
it's defined by state law, and it's Washington State law is very expansive. The ultimate charging decision that Kelly and our offices do, many of those that are sort of tangential family relations, we will amend out. But the initial charging is pretty wide for DV.
Curtis?
Just for clarification on DV, and I apologize for asking this question, but I don't know, but where do you draw the line between the domestic violence? Because obviously, if an officer shows up at a household where there's physical violence going on, then that's a no-brainer. But what if my spouse and I are having an argument in this apartment, and the neighbor calls, and the police shows up? Is it true that one person has to be removed from the home?
If a charging decision is made that they believe that reasonable, terrible suspicion that a crime's occurred, they have to, there's a requirement that they book the person they believe committed the crime, that someone has to go to jail if there's probable cause. When there's no probable cause, that's a different animal.
But that's an interpretation, right?
Well, no, the reason, they have to meet the threshold boundaries. It's a legal definition as to what probable cause is. The officer believes he has probable cause, or he or she. They have to make a decision as to, do I have this? And if I do, which one of the parties, that person, while they have discretion on most other crimes that are non-felony as to whether or not they book, the state legislature has said you have no discretion on DV. You shall book.
Yep.
Typically, that's determined to be the primary investor.
Right.
Primary aggressor is in that piece.
What I'm getting at, disparity again. Sometimes if an officer shows up at a household where there's a person of color involved in this domestic argument, because I'm obviously if there's violence, we're not talking about that. But if my spouse and I are having a verbal confrontation and the officer shows up, chances are the person of color is going to jail. I have this conversation with too many of our people about this, and I think it's an issue because it goes back to the disparity issue again. That's why I say that if an officer shows up and me and my spouse are having arguments, which all of us who have people in our family sometimes get into arguments. So if the policeman shows up, someone has to go to jail. I think that's something that definitely needs to be looked at. Excuse me?
We can't take people to jail for an argument.
Yeah, you have to meet the threshold, yeah.
Just by developing probable cause to determine whether or not a crime has been committed based upon that probable cause. That is when the arrest is triggered. That's the only thing, the only basis by which we can use to make an arrest. We can't arrest people for just having an argument.
So I think this is a valuable conversation. It's getting at sort of the discretion, it's getting at implicit bias, it's getting at different evidentiary standards that are all worthwhile in terms of discussing as a group and figuring out how we can inform, provide information to all of our officers across the system so that they're making an appropriate decision. But I want to bring it back to the target populations to wrap up before we take a quick break. So Teresa, if you want to ask.
Just a quick question about the misdemeanor holds, do we have this by court?
I believe, yeah, we can break it out by court. Yep. So last slide is sort of getting at this idea of risk level. We all know, and our law enforcement officers can also speak to this at length, that we're seeing a lot of the same people come in and out of our jail. And that's for a lot of reasons, some of which Caitlin went over earlier in terms of factors that lead someone to come into repeated contact with law enforcement and with the criminal justice system. So we looked at who is being booked and released multiple times, not booked and released as in brought in, taken their information and kicked back out, but people who are brought into jail multiple times in a year and may be held or may be booked and released. So just for misdemeanors, not including felonies, which bumps this number up, we have 355 people that we see brought in or released from jail 3 times in a year. 206 of these individuals were brought in at least once for failure to appear or failure to comply, once again underscoring our FTA issue. Also 69 or 19% were brought in at least once for domestic violence related charges. And their total length of stay altogether was over 7,000 days in jail, which translates to just under $1 million being that these people are costing us. So the question that our committees are grappling with and that this full task force needs to also grapple with is there a better way to invest this money, $1 million or less, to make sure that these people are stabilized in the community and they're not coming back into contact repeatedly with the system. We also looked at the population of people released from jail 6 or more times solely for a misdemeanor, and that's 36 people. They stayed in jail about 1,100 days altogether, and the total cost to incarcerate this population is $151,000. Again, just misdemeanors. So with that, we always like to give a break after data. Let you guys digest it for a little bit. We'll take a 6-minute break, and then we're going to move through fairly rapidly the recommendations, and then we'll discuss those recommendations as a group. So we'll see you back in 6 minutes. All right. we are going to get started. Tom and Kelly working out some last minute plea negotiations on the side over here. Okay, so after we had identified our target populations with our data, and obviously there is still additional data that we can and should be pulling, so continue to flag those. The committee has moved on to targeted investigations, so looking at different research and initiatives that address these different populations and trying to figure out what may or may not work locally. So we still have some investigations pending, and I'm going to just run through those so you know what's still in the hopper. So we'll go committee by committee. First of all, Rethinking Incarceration is looking at community correction center models. This was something that was recommended by the Blueprint for Reforms. It's widely endorsed, but what we've started to learn is that the way people sort of think about community correction centers is a little bit different depending on your orientation and your experience with the system. So the Rethinking Committee is going to look at a variety of models and best practices and develop a recommendation as to what they think would be most effective in Spokane. We have also had some really robust conversations about whether there are any low-level criminal offenses that would be better handled as civil offenses. So law enforcement has raised concern that it would really limit their ability to motivate behavior change or to curb inappropriate behavior. And others have also said that they're concerned that civil offenses often come with a financial penalty, and the people who would be charged with this probably can't afford that. So is it really going to fix or address the problem? So this is something that we're continuing to discuss, and hopefully we'll have more information for you soon. Community collaboration has been looking into developing a partnership with STA or other transportation services to provide free or more accessible transportation services to people when they need to get to court. We looked at one community in Hennepin County, Minnesota, that has a pilot initiative that's funded through grant monies to partner with Lyft and provide free rides to court and back from court. And so this is something that we anticipate they're going to share data out in January, but we thought it was really interesting, and we're trying to figure out other ways that we can make court more easily accessible. As you heard, it's a huge challenge for folks in the community. Also trying to figure out whether there are options to identify transportation needs at booking so we can start planning sooner and connecting people with resources sooner. Expanding court date reminders through our homeless management information system is something that we've been trying to figure out whether it's doable and helpful. And then also looking at victim notification and safety planning for people who are involved with domestic violence or family violence. So speaking of that, we wanted to drill down into our female population in the jail in a little bit more detail, because we know this population is increasing nationally and locally, and we also know, based on information and research that Vera shared with us, that oftentimes women or other folks, it doesn't have to just be women, who are held in jail also have experience with domestic violence. They might be a domestic violence victim or survivor. So we know that family violence does not always involve a female victim, but this is just a starting point for us, and this is some new information. So we looked at the highest charges faced by women who are held in our jail, and you can see that assault is the top charge. So then we wanted to look and see how many of those assault charges are flagged for domestic violence. And about 13% of all charges, but 10% of domestic violence charges are held on DV. And this, is that correct, Diane? It was 10%? So this translates in, I thought it was higher for some reason, but it's still a significant amount, and it suggests that there's an opportunity for us to invest in victims' services in our jail facility. And we also started looking at a model in Maine that specifically works with women who might have been DV survivors and connecting them to services when they're coming back home to the community. So this is something that's still under investigation, but I thought it was an interesting additional data point for us to consider.
So Maggie, before you, go ahead.
Oh, I was going to add something about that program in Maine. I know, so they are serving folks, they're screening women, Federal Services doing the screening to ask people, women, if they are actively in domestic violence or sexual abuse situations, and 74 out of 130 people they've interviewed say
And I realized I was misinterpreting something. I'm good.
Okay, great. So then our cost committee has been involved in a lot of investigative conversations, especially as our budget office sort of leads the way in drilling down into some of our cost centers in the jail. So we have looked at sort of the different amounts that we're charging different agencies, which we talked about already. And then we're also looking at specific costs. So we started, the budget office just shared last week that our booking cost is actually significantly higher than our per diem rate. It's about $298 to book someone into jail. So if you think back to our book and release population, that's a significant pressure on our jail, both in terms of labor and in terms of financial costs. We also started looking at costs by bond amount. And so and then also frequent utilizers is something we're still looking at. So I wanted to share some of the information that our cost committee looked at related to bail amounts. And as our committee members pointed out, this is purely a financial exercise. It doesn't necessarily consider the factors related to public safety that's included in Court Rule 3.2. But you can see that the number of people held on the highest charge of a felony on a bond amount of $5,000 or less without a hold, so meaning if this person had $500 for a bondsman, they could get out, are 82 people in our jail based on this snapshot. The total days that these people had spent in jail up until the day of our snapshot was about 1,900, almost 2,000 days in jail. The cost to incarcerate this population was nearly $260,000. Now, if we decided that instead of incarcerating these individuals, we were just going to cobble together money to cover all of their bonds, that would have been $75,000 roughly. So we would have actually saved money just paying all of their bonds rather than holding them for those 2,000 days in jail. It would have resulted in a cost savings of nearly $185,000. So again, we need to be thinking about what we're prioritizing and what's effective in holding people pre-trial, both in terms of outcomes for our taxpayers and for the individuals who are incarcerated, as well as for victims and everyone's families. We looked at the same numbers for misdemeanor populations as well. So these people are held only on a misdemeanor with a bond of $5,000 or less, and they could post that bond. There are 57 people in our jail held solely for a misdemeanor on bail, and they had spent 565 days in our jail so far based on the snapshot, so this number might increase. And the cost to incarcerate them was about $75,000. Again, if we paid all of their bond amounts, we would have actually saved about $26,000. So another jurisdiction, New York City, actually noticed that there was also potential for cost savings here, and so they subsidized the charitable bail fund called the Liberty Fund. New York has lots of charitable bail funds, but this one was subsidized in part by the city council, and their bail amounts were private donations, so the city doesn't actually cover the bond amount. But they found in 2018 that 87% of the people that they bailed out through this project made all of their court appearances. And they posted about $370,000 worth of bond. They recovered roughly $125,000 of that money. So if someone resolves their case, makes all their court appearances, they get that money back. This amount might have been lower because some people were still facing charges, so they hadn't recovered that money yet. But even with this discrepancy, even with this disparity in what they recovered, the bail fund still saved $1.5 million for the city of New York. And it resulted with some pretty successful appearance rates for their community. This is not something that was sort of decided upon as a recommendation by the cost committee. We're still meeting and having conversations, but I thought it was interesting, given our conversation about bond, for the full group to see.
Maggie, what do we know about how this is working in Spokane so far?
Good question. I did reach out to the Bail Project for some information. I was going to share this on a later slide. It's not included because we just heard back late last night from them. They were hustling to get us some data, so big thanks to the Bail Project and to Patrick. Since December 2018, the Bail Project has served 202 people locally. 72% are identified as men and 28% as female. 73% are white, 14% African American, and 8% Native American. And they, because it was such a last minute sort of data, that's I think about all we had. I don't know that we had their success rates, but I'll double check. What was interesting is that they do ask what the needs are of individuals who they're serving. And since they've been collecting this data, I think it started in May, they found that 82% of their clients noted that housing was a need, 81% said transportation to court was a need, 70% substance use, 57% identified as having issues struggling with meth addiction, 37% with heroin, 61% with mental health symptoms, and 60% accessing employment. So we're seeing a lot of the same challenges with our whole population, but that is some data that the Bill Project provided for us today. Yep.
Hit off the raw numbers right off the top again, just like percent.
72% male
All we need.
from the Bill Project.
Yeah.
So that's 202 people
202.
since December
Okay.
of 2018. 72% male, 28% female, 73% white, 14% African American, 8% Native American. And I'm happy to go give you the data after this.
Maggie?
Yes.
Quick
Mark.
question, both New York and our own program, are we measuring not just the compliance, but are we measuring recidivism?
I think it's probably too soon for the Bail Project to track that, but I do believe that you're probably tracking new criminal charges as well, so you can speak to that more.
We do track that information. We're still working on catching up. The data entry part is probably the most challenging part of my job, because I'm also trying to get in there and see people and bail them out. So I personally am a little bit behind on my data entry. I have a data challenge to get that completed by the end of the month and up to date, so we'll have better numbers after that.
Thank you. Yeah, thanks. And then what about New York and their program? Did they have any stats with regards to reoffense?
I think they, this was the data that I had available. Their other bail funds also are tracking this. And you'll see with some other initiatives that they're reporting new arrests as well. But because recidivism can be defined in so many different ways, we're looking really at the successful rate of appearance and whether or not they face new criminal charges during that time out.
Well, so is that captured, whether or not they face new criminal charges, is that captured in compliance?
I don't know if this particular
Okay.
bail fund, I'll have to double check because I was synthesizing some of the information that our committees digested, so I'll double check on that.
I appreciate it, because that's really the conundrum, right? It's like, what's the level of supervision? What's the appropriate situation where you let somebody out on their own recognizance in exchange for the community safety? And so it seems like you've got to have the stats on recidivism for us to evaluate whether it makes sense, and obviously as you're going along.
Diane, I don't know if you can pull up our old presentations to the cost committee, but I think it would be in one of those if you have a second one. But we'll work on getting it.
Oh yeah, I don't need it right now. I just want to make sure if we're going to do this and we're testing this, we got to make sure we're tracking that.
Yep.
That's the other side of this argument. Thank you.
And I would just add kind of generally across bail funds, I don't know about this specific one, but what you typically see is that the rates of FTA are higher than the rates of new charges or new arrests, depending on how they're measuring. So the bigger issue is usually the FTA.
Right. Okay.
I would say too, we could probably reflect back on an earlier slide that you had shared with the repeat high utilizers that would kind of show an indication of the recidivism rates, right? So if we've got people coming in and out of jail 6 or 8 times, but it's only this percent, then that kind of gives us an idea of what recidivism is.
Okay, so moving on to the targeted recommendations. The committees really were focusing on outcomes with these. We had a lot of conversations about trying to figure out whether something would be effective and looking at outcomes. So again, Mark, reducing that recidivism rate, reducing repeated contacts with our local system, increasing levels of safety for victims and our community, and also making the most effective, wisest investment of taxpayer money. Again, I'll reiterate that a lot of these recommendations track with what you heard in terms of Vera's focus group findings. So first, there are 3 shared recommendations across all of the committees. And then once we go through these shared recommendations, we'll break out the recommendations by committee. So first of all is supporting a redesign of the citation or summons that we use locally. Judge Smith couldn't be here today, but he loves to talk about this and advocate for it. So on his behalf, I'll discuss it today. This is what we use right now. It's provided by Sector, which is a state-run database or system. And as you can see, there's a ton of fine print, even when it's blown up. And it's really difficult to see what are we supposed to be looking at here. So here are these red circles. The one at the top is the appearance date and time. And then in the middle there it says, if you do not appear, this may result in a warrant for your arrest and detention in jail. So it's not highlighted, it's not in bold, it's not clear. Sort of the court date information is also not clear. So this is something that Judge Smith would, and others across all three committees in fact, would really like to see changed. Now it's also really difficult to get changed because it is a state system and it's not something we can just say, hey Chief Meidel or Sheriff Knezovich, can you tweak this? But again, we looked at New York who had done something similar. You can see their old system on the left of this slide. Up at the top, they have it titled as complaint or information. So again, not super clear that it's a criminal proceeding. And then you can't even see where the court date is on the left side because it's at the bottom and I cut it off. On the right side, you can see their changes. So they made it very clear that it's a criminal court ticket. And in the middle, which you can see hopefully on your paper, they have in bold and asterisk that to avoid a warrant for arrest, you must show up to court. And then they have the court information and addresses. So they saw a 13% increase in their appearance rate just by redesigning this. And that's an incredibly low-cost solution for us. And so the committees recommend that we develop some edits and submit them to the state and say, this is what we support as a community. We have a lot of stakeholders who support this, and then provide the recommendations. Again, low cost, potentially high yield. Yes, Harry?
Are we looking to get some of the other large jurisdictions across the state to also do this, so it's not just
That's
us?
a great, yeah, that's a great suggestion. I think we could definitely do that. So we'll add that to our recommendations as well.
Is it an agency decision or is it legislative action?
I think it's an agency decision, and what they told me when I asked them via email was like, yeah, you can submit your requests and we'll take them into consideration. So I think having, as Carrie is sort of pointing at, having a cross-section of supporters would be really helpful.
Yeah, because this is something that the state controls, and Sector is now in the midst of sort of its end of life. Regardless of what we do, they're starting to plan for the next system because it'll take them a good, almost decade to get that up and running. So I'm not sure what their appetite is for change, but it is something that we should really, literally, low cost. One of the things that Judge Staub has been doing is we have a 7:30 a.m. Tuesday meeting on forms that all the principals in municipal court do. And one of the things that she has been pushing, which I think makes our court administrator, Howard Delaney, sort of twitch a little bit, is redesigning all of our notices that go out on every type of hearing. And it doesn't make legal sense, but she wants to put sort of the order at the top, which is the court date and when they shall go. And it sort of seems bizarre to all of us lawyers, but at the end of the day, if it gets us there and we can legally do that, then why would we not make big, bold numbers and location? And
twinkle and flash.
Yeah, and she always likes everything to be left, not centered, because that was one of the things, all of our forms, it was just like we go to these classes and these seminars and we're learning that literally the way we've done things because it looks nice legally doesn't actually work with how people read and understand.
We always knew that.
We just didn't want it to change, but now we're being forced to, and I think that Nick and I are very agreeable at 7:30 in the morning just to get those meetings done with. So, a lot of consensus.
Well, it makes sense you're on our Rethinking Incarceration Committee. You guys love those early meetings. Yes, Tony.
So, have you ever had an app for this? I mean, we send out notices for medical, dental, all your appointments. Every one of our patients, employees there have a phone. Maybe they get $100 off the bail if they agree to the app or agree to it.
You're leading us into our next slide right now. So thank you for that. Tony's absolutely right. Medical reminders are used widely, and and we know that they're very effective in terms of court date reminders as well. They increase appearance rates 30 to 50%. And again, in New York, they did a redesign of summons and then also did some effective court date messaging, and they avoided about 20,000 arrest warrants in a single year as a result of those two initiatives put together. We also see really successful rates using court date reminders in California. So we do have court date reminders locally, lots of them. Municipal court has a free court date reminder that is opt-out, correct? Opt-out?
Opt-in.
Opt-in, okay, and then district courts is the opposite. District court has one, and our county public defenders uses a court date reminder system called UpTrust. So there are some gaps with these. As you can see, municipal court, you have to come to court the first time to get enrolled, same with district court. And for our county public defenders, you need to be assigned a public defender to be enrolled, which can take a couple weeks before your first court appearance. So we are missing people who are booked and released from jail with these court date reminders and people who post bond, which is a significant population, about 13% of our bookings at the very least. We are in the works right now trying to rectify this. So we're having conversations with detention services, county IT, and UpTrust trying to implement court date reminders at booking, where they can just pull information out of our jail database. And once you're booked in, even if you're released, you're already opted into this system. There is a challenge with getting the right telephone number. Sometimes folks don't want to give their correct contact information to the jail, understandably. So that's something that we're going to have to work through and try to continue to refine and improve. But those conversations are underway. All three committees really like this idea, and so the recommendation is for the board to support continued investments in our court date reminder systems. The court date reminder system in Tom's office at our county public defenders is two-way. It allows the public defender to communicate with their clients, and it also provides these automatic court date reminders. That costs about $20,000 annually. We're anticipating that implementing the court date reminder at booking, the integration fees would cost about $10,000 on UpTrust's side and additional money on county IT side, and then $10,000 thereafter. To provide the automatic court date reminders. What's nice about UpTrust system is that they provide their court information, the consequences for not coming to court, and then they prompt people to start planning, whether you need to take your work off, figure out childcare, things like that. And that's what they found was most effective. You need to have the consequences with social services or planning. So that doesn't exist right now at our court level, but with UpTrust it does. Our next shared recommendation is in continuing and expanding support and investments in community-based services, specifically housing, which you've heard a lot about, and behavioral health treatment. A couple interesting studies that inform this recommendation. One is a study out of Stanford that found investing in and placing one nonprofit in a community significantly reduces the crime rate, including property crime and violent crime. So this just sort of indicates that investing in our communities improves safety for everyone. We also see that in New York, they've done a lot of different investments in their neighborhood initiatives, and that includes improving infrastructure, improving community engagement, employment opportunities, and again, they're seeing a reduction in crime as a result of these investments. So as folks that work and are responsible for the criminal justice system, there are things we can and should be doing better, but there are also opportunities and needs that fall outside of our purview in the criminal justice system that also must be addressed if we're going to have a significant impact on our levels of safety. Moving into the committee-specific recommendations, so those of you who don't sit on a particular committee, these will be new, this will be new information for you. Rethinking incarceration. All liked this program called Supervised-Release. Again, we're looking at a model in New York for some direction here. And the Supervised-Release program is in lieu of bond. So if someone would make a good fit for this, sort of meets the criteria, they are sent to a social worker who basically works as their case manager, and they're connected with voluntary services. The social worker works with a peer support specialist to also support folks in getting connected to services and coming back to court. They operate 7 to 7, so folks who have work can access the supportive services between work hours. And Mark, this sort of gets to your question a little bit, but 88% of everyone released to supervised release, to the sort of therapeutic case model system, show back up to court. 20% of the clients are rearrested once they're released, but only 8% of those people are arrested for a felony charge. In New York, they were expecting to serve about 3,000 people over the course of the first 3 years of the program, but they served over 3,000 in the first year, and now they're anticipating 5,000 because this program has been so successful and is so well loved by the sort of criminal justice system and the judicial officers.
Maggie?
Yes.
So on the 88% make all court appearances under this program, how does that compare to not in the using this kind of program?
Do you know
What's
what our FTA rate is much lower than that, but I don't know what it is comparatively speaking in New York.
I want to say it's like 70, but I would have to fact check.
So
Well,
higher.
and that's a similar question I had is this is fantastic. So what is our percentage in terms of events? You know, so we could make a decision about whether this is a good investment. I'm highly likely it is.
Yeah, so I mean, anecdotally, we have information. Judge Smith, as I mentioned, sees only 30% of his docket for arraignment typically, but we've struggled to create a baseline for our adherence rate.
I would say anecdotally in municipal court, it's probably 25 to 40, 50% that don't show.
For the first appearance.
Right.
For the first.
Well, so essentially you're looking at 88% versus, I would say, you know, when I was a practicing in court prosecutor, it seemed like at least a quarter every docket, and then some, depending on what you're doing, it can be much worse. But we would have to, you know, establish our baseline to see really where we're at right now. But FTA's really sort of drive the ship.
Are we studying this as part of the PSA implementation?
We're looking at FTA rates and new criminal charges as part of the success of the public safety assessment, which is our pretrial risk tool. We're trying to get improved data because right now we can only see people who are booked into jail on a bench warrant, but not individuals who miss court, have an outstanding bench warrant that has yet to be served. So there's a gap there in terms of the rate of appearance. I'm going to keep going because we got some more recommendations to get through. So supervised release, just wrapping up, they estimate that it costs about $2,500 per participant. Participants stay in the program on average 3.5 months. If we were going to take a 3.5-month jail stay and calculate the cost of that, it would be about $25,000 a person. So again, potential for cost savings here with investing additional resources into individuals in the community. We have recently launched a bail review pilot with MacArthur funding in our pretrial services office. And basically what happens is a mental health clinician is paired with a pretrial services officer, and they look at folks who are held on a $5,000 bond or less, who also have behavioral health issues or symptoms, and they provide voluntary services for that individual, voluntary case management services. And if they can get that person connected with a bed date, if they need inpatient treatment or other housing services or anything like that, they'll bring it back before the court with the public defender, and if the court is comfortable, then they're released to these voluntary services. So it's trying to, again, identify what people actually need to be successful, show back up to court safely without sort of wasting an immense amount of our resources in the jail. This is just a month's worth of data. We're limited because Superior Court's dockets are so heavy that they can only add 1 case, 1 to 2 cases per week, so we're slowly building this program up. But we saw in the first month that 8 people had been successfully connected to treatment. 4 of those individuals were facing possession of a controlled substance charge. That usually carries about a 26-day length of stay in our jail. And we were able to cut that down, saving just across 4 people, 51 days in jail or $7,500 in savings. So there's been some discussion and debate about whether this should be a voluntary program or not, but really we were trying this out based on the model in New York with their supervised release program that does involve voluntary services, not wanting to overburden people if they're being safe in the community accessing services.
Maybe can I ask that you use some caution when you say things like savings, because it makes it sound like those are dollars that could be moved and spent elsewhere.
Thank you. What should I say instead?
I would say that it buys your capacity.
Buys capacity, okay.
It's not actual dollars.
Great, thank you for the clarification. Yes?
Do you happen to know what tools used for the screenings? That was just some level of cost.
So we look at just the bond amount, and then she will do sort of a mental health assessment. I believe she's doing chemical dependency screenings. I'm not sure what else she does specifically. Okay, I will ask. Liz, you got that one down? Yeah, great. Okay, so the recommendations here are to increase this program by expanding it to municipal and district courts. Right now it's only in Superior Court. I think that we're well positioned at this point to engage in conversations with municipal and district courts to do that if there's an interest. And then also increasing the number of cases heard on Superior Court dockets as capacity allows. Warrant Fest is something that we have done locally for a long time, or relatively so, and the 3 courts are starting to partner in doing these, where basically we say, come back in, recall your warrants, and we'll set a new court date without arresting you for a specific kind of warrants. There's a community, again in Minneapolis, that does this, but they provide an opportunity to resolve the case at Warrant Fest, so that you're not just setting another court date, potentially risking a failure to appear. They do this by providing opportunities for community service at the site, so that you come in, you get your warrant recalled, you do community service, your case is done. So this is something that a lot of our committees endorsed. The sort of caution that I would give with community service is that there was a recent report released that found that community service can expose people to some risky or unfair working practices or working conditions. So we want to make sure that folks are safe when they're doing community service. Also, the report suggests that what's been really successful in other communities is if you give community service, give them the opportunity of completing education or treatment or something else as credit for community service, so that you're actually helping people stabilize. And then finally, if you are going to do community service, do something that gives them a long-term economic opportunity, that maybe funnels them into a longer-term employment. So that's something for us to work out as we move forward with this recommendation. Another recommendation is coordinated releases and reach-ins. So we all really like the idea of this warm handoff, as we call it, but we have sort of struggled to operationalize that. So there's a lot of different examples that we can look to across the country where our jail staff partners with community-based providers to either continue coming into the jail, providing case management and planning for folks, or developing a really meaningful and effective handoff at the jail doors. So we looked at different programs nationally. Folks really liked this. We also looked at a program we have locally that's funded by the Bureau of Justice Assistance. It's a re-entry pilot that is done in partnership with Better Health Together. And Better Health Together works with community-minded enterprises and SNAP. And basically how this works is that people who are eligible for this re-entry pilot are referred over to Better Health Together and a community health worker. The community health worker goes into the jail, meets with this individual, does a needs assessment, and starts the initial planning process, and starts establishing rapport, which is really important. So then when the individual is released, the community health worker continues to provide supportive services and helps them stabilize once they're back in the community. Because we know that it's so easy to lose someone once they're released. And then you struggle to find contact and provide those services. So it's been critical that the jail has allowed us to access clients while they're still incarcerated. It was challenging to sort of break down all the silos necessary to set this up. It's also been challenging because folks who are sentenced for time served are released before our community health workers can even get in there. So if we can formalize this process a little bit more, increase access for community providers, I think the impact of this sort of model would be even more meaningful. And I would just mention that we've had a lot of success with this pilot, even with our limited numbers. Our community health workers, with the support of Better Health Together, have gotten people who've been chronically homeless their whole lives housed for the very first time with their families. They also have people who've successfully completed the program and are now sitting on Better Health Together's various sort of community boards. So it's really promising. Yes, Sabrina.
I would just say that my concern about this prior to release part is that this is still only focusing on sentenced individuals. At least that's what it was, unless it's changed over time. But it was a very narrow slice of people who could be eligible for it.
Yeah, so we've actually lifted a lot of the limitations in order to try and capture a broader amount of people, and you don't have to be sentenced to be in this this reentry project. And I think if we expanded it, we certainly wouldn't want to limit it just to our 16% sentenced population in our jail, knowing that folks can benefit a lot from stabilizing pretrial. Yep. Another recommendation from the Rethinking Incarceration Committee was incentivized probation. So as you heard, municipal court is doing a lot to shift to sort of a case management model and a more therapeutic model for their probation. In Louisiana, they implemented incentivized probation, where as long as you were successfully meeting with your probation officer or meeting the requirements of probation, you're getting time knocked off your sentence of probation. So it sort of limited the reach and the possibility of probation sort of keeping you ensnared in the system. If you had a violation, they also allowed for sort of administrative sanctions or consequences rather than bringing someone back to court or back to jail. This allowed Louisiana to reduce the number of cases on probation and also reallocate resources and attention away from folks who were doing well in the community and towards folks who maybe needed some more support. Moving on to community collaboration. One of the primary recommendations was increasing the use of peer support across the criminal justice system. So you heard that Supervised-Release in New York includes peer supports. They're actually increasing the number of peers they work with to make sure that folks are successful once they're released. You can see on the left side of your paper or the slide all of the things that peer support specialists can do, and on the right side some of the challenges in implementing peer supports across the criminal justice system, including lower pay, including personnel policies. In order to be an effective peer, you need to have had similar experiences, which can include criminal history, which can also limit some people's ability to access employment in some contexts. So that's a huge challenge to this as well. Another need or challenge is making sure that there is tailored and meaningful supervision. Because peers have such unique backgrounds and such a unique role, they really need to make sure that they're supported in a meaningful way. We have a lot of organizations in the room that work with peers though, so I think if this is something we can expand upon, there's a lot of guidance and wisdom that we can use from our community partners in making sure that these programs are effective. Another recommendation from our Community Collaboration Committee is limiting overnight releases from jail. So we can see that about 29% of pretrial releases happen between 8 p.m. and 6 a.m., and 25% of our sentence releases happen overnight as well. The sentence releases are easier to plan for because they're sentenced. We should know when they're getting out at least a little bit ahead of time and expedite that or plan around it. And we can also do it for pretrial. And we looked at some states, Texas and California, that have passed legislation limiting overnight releases because we know that resources aren't available or open overnight. Transportation might not be working. It's hard to get to safe housing. Also, if there's safety issues, it's really not great to release someone at night where things can be difficult or go wrong with limited support. So the recommendations are to avoid releases whenever possible overnight, move it up earlier so that folks are released when resources are still open and available. And then if you do release someone at night, give them the option of having a safe waiting space that includes a dock or a charging station for their phones so they can call loved ones. That includes maybe some snacks or water, refreshments, anything that just will keep them there and safe until morning, and then developing sort of recommendations and policy for making sure those folks are safely transitioning out once morning comes. Another recommendation that came from a community partner, Aaron, I think it was, and then was really sort of taken with enthusiasm by our district court Judge Smith, is trauma-informed training. So there's a lot of people who can speak to the fact that when you come into one of our courthouses, it doesn't feel warm or welcoming, whether or not you're facing criminal charges. And so in order to make people feel like it's safe to be there and to come to court and show up and have things resolved, there was a recommendation to have trauma-informed training for our courts. So you can see sort of there are lots of different trauma-informed principles, and the recommendations that came out of this was to get our courts trained and really prioritize our therapeutic courts as well. We fortunately have many local trainers who've been trained by one of our technical assistance partners on trauma-informed training, so we have resources here to do this. And if you're here representing any office or court that wants to pursue this, please contact me. But I will also be contacting you to offer this as well. Finally, our cost committee. Again, you saw that a lot of the conversations in our cost committee are still in the investigative stages as we try to figure out the costs and the financial centers in our jail. But the primary one that came out of our cost committee was looking to expand our electronic home monitoring. This is specifically for our sentenced population. And you can see that there are state limitations in terms of who qualifies for or who could be eligible for electronic home monitoring. In addition to those state requirements, we have detention services policies that further limit the eligible population of these people. So you can see them all outlined on your slide. So, based on a September 17th snapshot, a sort of limited review of our data showed that 63 people met at least some of the state requirements, and we had 25 people enrolled in electronic home monitoring. It costs individuals to enroll in electronic home monitoring. There's a $25 initiation fee, and that costs them $4 a day thereafter for however long they're on monitoring. So there's potentially a burden on people, and potentially it filters people out who can't afford this. It costs us about the county, it costs $3.30 a day for each device that is in use, and just over $1, about $25 for any device that's not in use and is just in storage. And then it also costs staff time to check in with people, monitor people, make sure that they're staying safe. So 1 year of electronic home monitoring just for the device, not including the staffing costs, would be about $1,200. And for 1 year of incarceration, it costs about $51,000. So this is something for us to continue to look at as well, see if there are limitations that we're imposing internally that we could lift that's still consistent with state law. Okay, so we made it through. Your very last slide, you can see sort of our target populations and how each of our recommendations fall under the target populations. So we have recommendations for every single population except our contract beds, which is still in conversation, and then multiple charges or charging practices. So what we are going to ask you all to do is to take a well-deserved final break for the day. We're going to pass out some little stickies, and in the back over here, underneath the resource sign, you can see that our target populations and our recommendations are listed out in sort of a horizontal line. And what we want folks to do is, during your break, go over and put a green sticky under any of the recommendations that you endorse, you feel comfortable moving forward and planning, a yellow sticky for anything that you sort of like, but you still have questions about, and then a red sticky that you feel like this is not going to be something that we could do locally, and we should not prioritize it and use our time and resources to develop it. So green for good, yellow for maybe, and red for no way. So if you need more stickies, feel free to come grab some. And I'm also going to post another sort of blank sheet. If you have other suggestions of initiatives that you want us to look at that we haven't presented today, feel free to write them on that as well. So we'll come back in about 10 minutes. The blue is a bonus one. We difficult as adults, but good job. So I'm excited by what we're seeing. Excuse my back, I'm going to take a look along with you. What we're going to do is just, it looks like Supervised-Release has broad support. Investment in community-based resources, also broad support, so maybe drilling down into what exactly we should be funding will be helpful from our committees. Expanding the bail review pilot is maybe on the fence, so we'll come back to that. Peer supports has some yellows, same with limiting overnight releases. Electronic home monitoring has one red dot, and coordinated releases and regions is a little bit on the fence, along with resolution at Warrant Fest, and a couple of questions about incentivized probation. So what I think will be helpful is to look at the ones that are heaviest yellow first, so that we can generate some questions and we can get some clarity as a group about whether something is in a red or a green category, and then move forward from there. So let's start with expanding the bail review pilot, which has some yellows here and here. Can anyone who is brave enough, now that you don't have the anonymity of the exercise, speak to maybe some of the questions or concerns they have with expanding this program? Yes, Brian.
When I looked at it, it seemed like a great idea, but it seems like, and maybe it's just because it's just starting, but the numbers are so low. I'm trying to figure out how can we expand that and maybe look at other things I've been saying for a long time. We need to have one person who's pretty neutral, just looking at who's in the jail, who probably shouldn't be there for all sorts of reasons, not so much, just so that we can create that capacity that Teresa was talking about. So that was my really only concern, is like, how do we scale this?
Yep, and we definitely, I think having it housed in pretrial services tries to get at that neutrality, getting an office that is providing information to all of the parties. And it is a pilot, and it is just starting, so yeah, the numbers are limited. It is funded through the Safety and Justice Challenge, so we have at least about a year and a half to go on it to generate some additional numbers. But expanding the pilot will help us generate additional data as well. So great points. What other questions or concerns do folks have? Yes, Barbara?
I had a yellow there too, just for the numbers. And
okay.
The recidivism, Mark's point too, just to see how well it's working and what it's generating.
Okay. Thank you. Any other questions, concerns?
I think maybe just like a little bit more information on exactly what it is would be useful, because I'm thinking this is probably what I've been hearing murmurs about, that mental health has got a grant for, jail mental health got a grant for case management, but I don't know what.
No, this one is not run by Detention Services Mental Health, it's run by pretrial services, and they have a clinician in there doing it, so I'm not familiar with that. We can get more information about that grant that exists for our task force. Yep. Anything else? There are a lot more dots. Everyone's concerned about the numbers? Yes, Mark?
Well, thanks, Barbara, for covering the main page that I had a concern on. And you'll notice I just want the record to reflect I didn't use any of my red dots. I just wanted to try and be very
Mark.
Yeah, I fought for them, but I didn't use any. The issue I've got, and I think it just comes down to, I'll just state really quickly, I've been involved, was involved in my past life in a lot of these issues, and I'm a firm believer in many of these programs and other programs. But if you're going to sell this to a system that you're trying to make a culture change shift to and including our prosecutors, and you're going to sell it to the victims, and you're going to sell it to the community, and you're going to sell it to the business community, you got to be able to substantiate you're still keeping them safe. And so that's why I keep coming back to recidivism. I'm all in as long as you show me that I'm not interested in, frankly, as a citizen, in whether it costs me more or less. I'm interested in whether it costs me less and it keeps us safer. So if you can do those two things, I think that's the sweet spot. And if you can't measure that or you aren't measuring it, then I would suggest you don't do it, because you're just going to build mistrust.
Yep, thank you. And so I think the thing to point out with this initiative is that it is a pilot. And so getting to the fact that we need more information and data on the numbers and the success rates, in order to get that, we're going to need to increase the people that are coming into it so that we can do that and then evaluate at the end of the program, okay, was this worth expanding in sort of a more sustainable model, or should we say goodbye to the pilot as it operated? All great points. Anything else before we move on to the next initiative? Okay, next up, it looks like Warrant Fest, resolution at Warrant Fest had a red dot and 4 yellow question marks. So who wants to share what they're concerned about, what they have questions about with this proposal?
I put a yellow dot, and it was
Okay.
because of the type of charge. There's some cases that I have no issue with us resolving at Warrant Fest, but at the same time, there are plenty of cases that, it really is very fact specific on to whether or not that's a good thing, and what type of resolution are we talking.
So figuring out what charges are eligible for it first, and then taking it from there. Great point.
I had the same
Yes, sir.
concerns. Some it will be appropriate, and others it won't.
Tom?
I'm the red dot. I don't, I mean, it always goes back to, does the attorney have enough time to spend with their client and go over their case? Not a rush to resolution. And I think people would just be doing the same thing that we heard about earlier. They'd be taking pleas to get this over and done with, without really understanding the consequences. So
Really quickly, just to respond, is there any sort of solution that you could imagine with endless resources, just as a hypothetical, that would address that challenge that you see with this project? Or do you think, no matter what, it would be something that would be insurmountable?
If the prosecutor isn't that concerned about the case to begin with, that they're gonna give them the resolution.
So Tom's
Withdraw the
solution is
warrant.
dismissal. Any solution in terms of providing meaningful representation prior to taking community service or whatever the alternative is?
Well, we would have to identify those individuals that are gonna show up for Warrant Fest ahead of time, so that we could have a possibility of a conversation with them before they show up.
Maggie, if I may.
Yes, sir.
I think identifying, maybe having a public defender there to do some screening. There are some that are clearly appropriate for that kind of resolution, and maybe be very cautious about the others because of the implications on future cases they may have as, and again, not fully understanding what it is that they're doing. I think there's a balance.
We are at Warrant Fest. We are there already now.
Oh, okay.
So Curtis and then Commissioner French.
Yeah, the only thing, I was just actually gonna kind of echo that a little bit. I think that that's a concern, that, I mean, it's an obvious concern that we have as a community, but, making sure that that the populations that we're addressing, or impacted populations, are actually informed enough to make good decisions, right? Because making good decisions has been part of the problem, right? That's part of the dynamic that's at play here, so making sure that we're being very intentional about providing that opportunity for good, informed decisions. So whatever one, I mean, I'm green on that, but I hear that, and I actually agree with a lot of that. Like, how do we kind of capture that as a community and go, hey, so how do we set this up? So if this is a serious one and you weren't gonna go to Warrant Fest anyway, but you were thinking about it, here's somebody maybe you can call and talk to and get counsel on prior to coming in to be able to make that, to have that, resolution or whatever, just to steward it well.
Sabrina, we'll come back to you after Commissioner French. But I did want to mention that we also have had conversations with Uptrust about being able to blast people who have outstanding warrants with a reminder for Warrant Fest in the future. So that's something else that we're looking into that we didn't mention in the slideshow. Commissioner French.
Yeah, I just wanted to make sure everybody was really clear that the term endless resources was just a hypothetical.
Just
to make sure we were clear.
Sabrina.
I was just gonna comment, there's been a couple of different organizations, one locally, one on the other side of the state, doing like LFO Reconsideration Day, where they have judges and, prosecutors and whatnot all in one room. And they actually have it set up with an RSVP system. So people can go on Facebook or to the event or to the page and RSVP that they're coming. So that way their counsel can have time to prepare for them being there.
Great. And I know that there have also been local conversations about an LFO Reconsideration Day as well. Yes, Kelly.
And one of my concerns is to make sure that if we're talking about resolving cases that involve victims, they have rights to be present and to be heard. So that would be a category that it might be difficult to resolve in that type of scenario. Because you don't know who's going to show up to then notify victims to show up or to gather restitution, whatever it might be.
So making sure that we might need to address that with the eligible charges. Great. Any other last comments? comments on Warrant Test? Yes,
Can I
Liz?
just ask a clarifying question? What is the proposal that if you do community service on site, the charges will be dismissed?
The way that I understood it as being practiced in Minnesota is that the charge, that's the sentence for the charge, so it's resolved, but that doesn't mean that we couldn't also look into an initiative that is, a dismissal as long as you successfully complete the community service.
So,
Yes, sir.
just real quick, that was my other concern, is just back to the victim, is it has to pass the straight face test. So whatever they're gonna do for community service has to be somewhat correlated to the crime they committed, so that that victim feels like justice was served.
Yeah, and I think that might be a case that our prosecutors are going to argue should be excluded from being eligible for this. Okay, great. Moving on, looks like the next one is Incentivized Probation. It has a couple of yellow dots. Anyone want to speak to what those dots might represent? Any concerns about Incentivized Probation?
They must have left.
It's helpful, you're not we won't villainize you for being one of the two dots, but it's helpful to know now so that we can decide, that's a great point, we should scrap this before we get too deep in.
I guess I'm one of the yellow dots. I just wanted, again, more information about it and what that would look like here. I'm reading what they did in, Louisiana, but it reduced their caseload by what, 196 people? So how valuable is it?
It was higher than that.
Are we actually helping people? Is there any kind of the community resources to back them up to prevent them from, messing this up and extending their probation to the end? Are we putting too many requirements, conditions on people that they're having trouble meeting? Those are kind of the things that I would want to see. Like if this was going to be a supportive service or we're incentivizing it, so we're also going to punish it more, that would be my question.
Any other questions for this one? Okay. Next up, expanding peer support. It was largely supported, but there was one yellow dot representing one or many people in the room perhaps. So any questions, challenges? We outlined some of the challenges on the slide in terms of implementing peer support services. Anything else that we need to be thoughtful of moving forward?
I think I put a green one and a yellow one on. I think one of the areas that we see, this is so promising in terms of workforce development, but most of our partner organizations are very ill-equipped to actually manage and sort of support the whole team approach. So I think you've got to be careful when you're thinking about the economics of this. Do not undermanage or ensure that that management structure is in place. We are very, very supportive conceptually of it, and the financing side of it has to match up.
And figuring out the infrastructure as well, it sounds like.
I would concur. I like peer support specialists and recovery coaches, but I can't bill for them. So you need to do a Medicaid waiver at the state. So Washington State can put it in a waiver and we can charge for those services.
I would just say, as a formerly incarcerated person who's now helping other incarcerated people, for myself, I started at a deficit. Like I was just sharing earlier, the data entry part is probably the most challenging. When we reflect back on my history, I spent 10 years incarcerated during the whole technological boom. So that infrastructure and that supervision should also look like training and support a lot. It's caused me struggles in my own job because I'm 42 years old, I've never worked a corporate job before. So some of those things that I think need to be kept in mind.
Yeah, so I was gonna chime up on the peer support as well. So,
you know, I think that we're running into some issues, because it's an evidence-based thing, right? So, I mean, the reality is that it works, but are we utilizing it here locally in the way that it's been proven to work? I think that's kind of what the barrier that we're in, because we, you know, keep trying to do this and that, and some of the places that I've been engaged with, you know, they're doing a little wiggy-wonky with it. And, you know, the challenges is what's already been talked about are the supports, are the financial incentives, as well as the continued training, right? So is that being implemented locally here in a way that the model actually shows that it works? And some of the other barrier with that too is that, you know, I mean, there's two barriers that I actually want to lift up, and one of them is obviously, you know, we're dealing with peer support with people that have been formerly incarcerated, so what do you think their record's going to look like? You know, so, but yet there's all these barriers as far as the record, being able to do peer supports. Well, then you get what you've got, but you don't really have peer support. Peers doing peer support. So that's a dynamic. The other thing about that too is the issue of we're dealing with impacted populations that are now being carrying the extra weight, and this kind of has another tie-in, but I'm just going to go with it. It carries the extra weight of actually of doing that work in something that you've already had to process yourself. So there's an extra processing space that needs to happen with that. And we know that it works, but what I'm also seeing is that, and I talked with peers across the state, and what we're seeing here is that extra space isn't being provided. So in other words, you know, just like, I mean, I don't know if there's an example that I have with as far as social workers, but I mean, when we talk about, you know, trauma-informed, not trauma-informed, trauma care, right? So we're talking about secondary trauma, right? So it impacts people to do this work, and then when you're taking impacted people who know how to reach people that have been impacted by this work, but now they're being extra impacted to have this evidence-based effect that is shown to work, period, then there's not really space created for that processing as well. Does that make sense? Am I articulating that well? No? Okay.
I think if I can,
yeah,
I think
please, go
what
ahead.
Curtis is speaking to is the need for additional supervision and support, because folks who have gone through the system or similar experiences have already sort of entered the workforce with a significant level of trauma that they have to work through in order to be effective in their position, but then also providing the support that's required by their job can potentially expose them to additional vicarious trauma. So there's a lot of need for sort of processing that experience personally and then vicariously as well to be an effective peer.
That's a great way to put it. Yeah.
Okay, so I want to move, yes, Jen, and then we're going to move on.
You know, I think with the True Blood settlement that's going on, there's a lot of attention being paid to peers and running them through a certification process specifically because of these issues.
Yes, ma'am.
Because they're looking at integrating peers as forensic navigators into the court system so that they can help with issues of outpatient competency restoration and other types of programming that they're looking for these individuals. So the state may already have something in place. Information that I've received indicates that there is specialized training and a specialized certification for peers that are going to be involved in the criminal justice system. So you might want to start there and see what they already have planned and if that's something that would work with this.
Great. Well, sorry, I was just going to say, if we want to hire some people on a federal contractor, state and federal law prohibits me from hiring some people with some criminal history. So we need to either figure out a workaround about it, figure out a mechanism where those people can be hired again, but those laws upstream need to be changed before I can hire those people. So that needs to be stated.
All great points. I want to move on just because we have some important initiatives that I think we need to get some clarity on, but please feel free to come up and share additional challenges at the end of the meeting. Next up, electronic home monitoring. We have a couple yellow dots and one red dot. So can folks speak to any questions, concerns, challenges? Yes, Director Scarber.
I put a red dot up there, and the lone red dot. It's not a no, it's a timeout, because when you talk about home monitoring, it's easy to see the capacity, as Teresa would say, but there's a lot of different philosophies on home monitoring. It's, you know, whether or not it's a 24-hour program that if a person absconds, we go out and get them, bring them back. Do we wait till they're, you know, a week or so until we catch them again and then bring them back? So I just think that the philosophy needs to be more developed, and then the staffing model is more developed before I could be a solid green, is all I'm saying. Okay?
Any other yellows?
Yeah, yellow.
Yes, Curtis?
So, definitely concerns about this being privatized and the cost on, the cost on the population that obviously has prosperity issues, right? So that's a dynamic. Just to keep it simple, I guess, because I can be all scrolled out and unpack that in my mind, but those are the basic points.
Anything else, yes, Rena?
Yeah, I mean, there's just been so many studies done on EHM and the detriment to the communities that they are. And I would just add that this is looking at sentenced people, and that's such a small percentage of our jail population. Like, I mean, yeah, great, 63 out of 900 and however many people. I mean, that's a dent, but it's not a very big one when we're looking at 70% of our people are pretrial.
Yeah, and part of why we were specifically looking at expanding the current program was because it was only dealing with sentenced people, and because it is so controversial about whether or not electronic monitoring pretrial populations is evidence-based and effective, and sort of how we respond to people, and is it actually increasing public safety? All of those questions are sort of still out there and unresolved. That's why we were looking specifically at the sentenced one, but you're right, it's a smaller population. Anything else before we move on to the next one? Okay, next up is limit overnight releases. We have a couple of a red and a yellow on there. Anyone comfortable speaking about, yep,
I have a red dot, another timeout. There's a couple of populations that get released overnight. One is obviously the sentenced population that gets released. The other one would be the bond, and they know they're getting released. The judge is allowed to help me out with this. Keeping them in jail past their release date would be a significant challenge, along with holding on to the bond population. So, one, I don't know legally if I could do that.
So that's
if I could hold them past, just 1 second. So I would have to, I mean, it would have to be a really coordinated effort, I would think, to do something like that. I'd have to have some cooperation. And two, I'd have to see what it does to the population as far as holding that overnight, because I think it would actually drive our population up more doing that as well. So that one is a firm no until I can figure it out.
So I think your point is an important one, that we can't hold people past the release date, which is why there's sort of this release valve. So for folks who their time has been served and it's time for them to be returned to the community, that we offer them a voluntary sort of, here's a safe space, you can wait, use your phone, eat some snacks before we kick you back out. It wouldn't be in custody at that point, but it would require us to think through where do we put that and what does sort of security look like around that, and so there are some questions around there. So
yeah, because we've actually had suits against us for that before, so it'd have to be out of the jail somewhere.
Well, and voluntary, right? I mean, that's what we're talking about is people who don't have somewhere else to go can go there, but they're not required.
Yeah, maybe somewhere else on the campus or something.
Great. Anything else on that? Yes, Mark.
I didn't put a yellow dot on there, but it is something that concerns me, and that is just in general, when you put folks out on the street at night in our downtown, which is why I'm here, you set them up, I think, for more chance of failure, and consequently you're negatively impacting downtown. So it seems to me like you'd let them out when there's services available, when hopefully you'd have the network where at least they could find their way to a service or a meal or a respite area, as opposed to fend for yourself until morning time. That's just not a good recipe.
Well, we even talked in our subgroup about providing transportation, like to the one-stop shop downtown for things open.
And I think maybe just taking a little bit of a step back on it, instead of talking about holding them for till the next day,
maybe see if there's some procedural changes that could be made to release them earlier in the day, instead of saying, well, you have to stay an extra 24 hours because the judge ordered you released at 3 o'clock in the afternoon. Well, then that person should be priority to get out as soon as possible and not at 8 p.m.
Okay, moving on, because we have limited time. We want to save a few minutes for folks from the community if they want to say anything. Coordinated releases and reach-ins. This looks about 50-50 in terms of support versus questioning. So the coordinated releases or reach-ins are having community providers go into the jail to provide case management services, provide a continuity of care, and or coordinate with detention services staff to make sure folks are released to some sort of planning and support services. So what are the questions that are still persisting for folks related to this?
The reason I put a yellow because of something that was just brought up, that majority of our people are pretrial. And so what is the sort of, how big is your touch on the sentence population? Because you're going to have a small amount. And, you know, our average length of stays are on 18 days. So, yeah, I guess it's just, you know, when I'm prioritizing, it's how much is that going to help us for that?
Yeah, and I think to be successful, it would need to have, folks would need to have some pretty robust access, especially because folks who are the high utilizers that we saw booked multiple times a year for misdemeanors, they're going to get potentially released with credit for time served. So having someone in there while they're waiting to get that credit for time served to plan with them is going to be critical to this success.
And I think the practicality, right, of detention services, it kind of circles us back to the initial question, why do we need a bigger jail? Why are people pushing for a bigger jail? Is so that there's room to provide these services inside. Right now, there's not room. I mean, how would that look? Where would we put it? I'm sure Mr. Sparber is probably asking himself the same question. Where would we put it inside the jail as it sits now?
Add to the point about kind of the extent of the touch, there's a study by the Urban Institute that found even just having an initial meeting with a service provider can improve outcomes because it's a familiar face when you are released. You have, you know, someone that you've met and maybe established some rapport, and even in that short time. So I wouldn't totally write that off.
Yes, Mark.
I mean, ideally, you would do this for pretrial as well, potentially. And I get the point that was made about the lack of maybe outcomes in terms of us trying to bring down the jail population. But to me, this is part and parcel with community corrections. I think we have to support this notion of providing the person. First of all, they're convicted, right? So they're there for more time. We got a better chance to be able to influence them, impact them, build that relationship. And then second of all, I think just building that transition path it's got to be part of the long-term recipe of helping people choose a different pathway than letting them out with their shoes and, you know, $20 and saying fly straight. So to me, this is like the quintessential community court. I'm a huge fan of it.
So I just want to highlight some of the other recommendations that were posted up there. Oh, sorry, Curtis, go ahead.
Just one quick one. Out of curiosity, how many people are we talking about on a daily basis that are being released that we need to be concerned about?
We have the annual numbers, so we have to break that down sort of on average by week, which I can't do right now because my computer's off, but yeah. It's about 25% of our sentenced and pretrial populations over the course of the year that are getting released between 6 and 8, or sorry, 8 p.m. and 6 a.m.
Some of them are bond. They know, like they bond out during the night. So they know they're getting out. I mean, it just depends on when they're posting their bond. And then the rest would be when their sentences get whatever time of the night that is. You know, and then what they get is they get credit for good time. So they calculate that time out for all of that, and whenever that time comes up, that's what it is. So.
Well, just to make this thing longer, but we're doing pleas up till the end of the day, so that, for example, this question down here, you're doing a plea at 4:30, the plea may be done till, the sentencing may be done at 5 o'clock, they have to be transported back to jail, they have to be processed out, And all that takes a lot of time, and particularly if they're busy, it's a meal time, people are coming and going, as you say, they're booking people, it's busy in the evening. So that's why the release can be 9 or 10 o'clock at night. It's not like they're trying to drag people out, it's just that they're really busy. So you get people ending up being released, what we might call late in the evening, simply because of the logistics of the jail. So it's not like you can simply pick a time and say, I'm gonna have somebody released. I'm gonna go sentence them at 4:30 and at 5:15 they're out the door. Which is why it becomes a problem when we talk about this, where they're gonna go and what they're gonna do.
Yeah, the judges would almost have to specify a time of release to do that. I don't know how you do that.
How do you do that? You're
Yeah.
so busy.
I'm confused. I thought we had shifted gears from the nighttime release into breach-ins.
Yeah.
We do.
Yeah.
Okay.
Just moving
Okay,
back.
here's
I just want to make sure that. Okay. Right. My comment was
It was
referring
me,
to
I
breach-ins.
scrolled out. It
That's
was
all right.
not you. I just went out there.
Easy, Mark, easy over there.
Okay, so excellent conversation. I just want to run through some other suggestions that were posted up and see if anyone else has some additional suggestions. One was eliminating bail in the vast majority of cases. There's some support, but fewer stickers, so I'm guessing some people might not have seen this or didn't feel comfortable voting on it quite yet. Another one was reducing numbers of people charged with drug felonies. Same sort of outcome, some votes of support.
Throw a couple of greens on there.
So these are things that we can bring back to our task force subcommittees and sort of parse through and think through and get some additional research on. Another one was related to contract beds, just saying we should keep federal pretrial detainees in order to facilitate public defender access. Are there any other recommendations or initiatives that you all know of based on your sort of expertise and position in the community that you would like to throw up here for our committees to consider? Yes, Tom?
I could just comment on the second one. I don't know how much Kelly knows about it, but the new process of charging what would normally be a felony possession is now going to be charged in limited circumstances as a misdemeanor possession in Superior Court.
Yes, Judge?
And that's exactly what I was gonna say, and those cases are gonna go to the early case resolution docket, as we've modified the early case resolution docket. So that is actually going to happen starting now, just this week or next. You're gonna see a start. It's obviously very limited to start with, but it's gonna, people that are maybe first, second, or third time through, up to 3 PCSs, the prosecutor's gonna look at the case, look at some other factors, but just may charge them as a misdemeanor. We'd be handling in Superior Court on the early case resolution docket, so we're moving there.
Does that include like an agreement to go to treatment or any of that, or is it just now
Just
it's a
charging
misdemeanor?
decision.
Okay.
So that gets back to our charging conversation. We didn't have any recommendations under that, but we could put this one up there, and we should definitely be tracking data related to this. It's also going to have a significant impact on folks in terms of their sentences, the collateral consequences of those sentences, and then also the sort of caseloads of Tom's public defenders being charged as a misdemeanor versus a felony. So lots to watch for on that, and great work to all of the parties involved in deciding to set this up and pursue it. So thank you.
A couple of odds.
Yep.
So one of them is bail reform, right? So, I mean, are we considering bail reform? Are we looking at bail reform? Are we talking about bail reform? We haven't really, I mean, it's been touched on, but it hasn't been like a real in-depth unpacking of what that would actually look like, or actualizing that, operationalizing that. So that's one. And then the other one is everything, and I'm trying to figure out how to quantify this, but all of this needs to be looked at through a racial equity lens and implementation of racial and equity toolkits, right? So that's, I mean, so I'm just gonna go back to what was brought up earlier, and I appreciate that I'm not the only guy in the room that's speaking out. That's why I just, space for people. But the reality is that it's already been demonstrated that we have been operating in historical bias for a long time. There are disparities across the board, period, point blank. And we need to launch from that reality instead of circling back around going, oh my gosh, there's racial disparities. Duh, we've got it. So how do we actually unpack the reality of why those are still here at this day and age, and really start looking at the dissecting of the numbers and the information to try to get an understanding of how they're still being implicitly and structurally implemented, right? And distinguishing between those points, and not saying that that's anything that's on one specific person or section, but it's pretty much all of us. And so what I really just am compelled to lift up is that, we need to develop our stamina as far as having racial conversations. And that's a reality that we're all embracing as community, from front end to back end, from community to from stakeholders to municipalities, all of us. Because when you look at the system, it's in all of it. And it's not necessarily because anything one person, one judge, it's a thing that we're all just kind of doing, and or by the fact that we're not actively dismantling it, we're automatically reinforcing it or just going along with the momentum it's already got on its own.
If you're not part of the solution, you're part of the problem.
Yes, ma'am.
Okay, so we're almost at time. I just want to go through and quickly rattle off any other recommendations for us to research. If you don't have a recommendation and you have a comment, you can see if there's time at the end of the meeting. So, any other recommendations going around the room? Nothing? Yes, Curtis?
No, Curtis. If you want to write. Yeah.
Recommendation?
Yes, being that we're talking about the fully incarcerated, one of the things I don't feel that we've touched on is the partnering with the business community, because actually what we're trying to do is get these people employed so they'll have something to do every day. So until we get the people that are actually doing the hiring to buy into some of this, we make our travels more difficult.
And I would add landlords to that.
Great. Yes, Brian?
I just, this come up in a couple, but that is dedicated housing for people coming out of the criminal justice system. Or, as I heard in municipal court, if we had beds with addresses, they could be released on pretrial supervision. So, and it's a little counterintuitive for us as a community, because we're like, well, we've got more homeless people than beds. We should give it to the people who don't have a criminal record active, right? But the challenge is, we know it's going to cause us the most problem and cost us the most money. We don't prioritize that.
Great. Any other recommendations or suggestions for research?
I would just say on the development community resources, again, my broken record, no adult of color behavioral health resources in Spokane, no culturally appropriate, that we need to carve some money out some way to do a bid, technical assistance that needs to be developed.
Wonderful. Okay. Huge thank you for everyone's participation. I think that the dialogue in this meeting was really meaningful, and I think it's clear that we have been meeting together for at least 3 meetings and several committee meetings in the meantime. I think there's a lot of really wonderful ideas and some clear direction that's emerging from this process. I do want to recognize that we have some people from our community who have been trickling in and out, and so we have about 7 minutes left if anyone would like to make any comments. There's some time. Otherwise, yes, Nick?
Yeah, thank you, Nick Fairley, Qualitative Services. Again, really appreciate all the work that everybody has done in putting these recommendations together. I think they're some great creative thought. One point that came up in the presentation that Maggie did, which was some numbers that I think were relatively startling, were the fact that 70% of people in the jail are pretrial, but only 3% of people are bonding out. Meaning that if a judge imposes a bond, it looks like about a 95% chance that that person is not going to be able to bond out.
So just really quickly, you're citing 2 different data sort of polls. One is our average daily population, which is 70% pretrial, and then our releases, which is separate from that, are 3% being released because of posting their bail. So it might result in some differences in the numbers, but absolutely, yeah.
Fair enough. I mean, but the reality is that, and judges may not appreciate this, that if they impose a bond, that may, in the vast majority of cases, mean that person is not getting out of jail. And I think judges may not appreciate that fact. They may think that they're imposing a $1,000 bond and that will inevitably result in the release, but I don't think that's reality. And so I think it really is incumbent on all of us to start talking about bail reform, because that really does seem like the driver for a lot of these issues, that people are stuck in jail simply because they can't pay the bonds. And the more, I think you all talk about that, and the more that's in the discussion, I think you will see a dramatic reduction in the jail population if we can talk about bail reform.
Judge Stop.
Okay, so I get frustrated when I hear that people are stuck in jail because they can't afford bond. The reality in our court is that we rely on the presumption of release for cognizance, and generally we will release people 5 or 6 times after they fail to appear. And maybe on the 6th or 7th time, we will start setting bail, and then we'll set bail at what we believe to be a reasonable amount. So for somebody to come back and say the only reason they're in there is because they can't afford bond, no, they're in there because they can't make it to court for whatever reason. Maybe they're actively using, maybe they have transportation issues, but we've reached to everything else before we get to bond. So it's frustrating for me to just hear that people assume that the first time they're in court we set bail at $1,000. No, we don't. We do everything we can to keep them out of custody while these cases are pending.
And I think the interesting point about bail and MTAs is that these are all issues that are not clear-cut or sort of isolated unto themselves. That we see failure to appear rates affecting folks who are held in jail, whether it's bond or for other reasons. And so, again, using resources and our thought and energy to address the failure to appear problem will also have reverberating impacts across the system, and vice versa with other initiatives.
I would just jump on with what Judge Staub said. When we first started with the bail project, and we talked to, well, it wasn't very first, but after Mr. Sparber took over the jail, he very clearly said our jail is full of people with failures to appear. It's not just full of people who made a dumb mistake. And that's really, we see that a lot. I mean, we see a lot of people who don't, and we bail them out. But we also see people who do have quite a few failures to appear. Some of the things that jack up those numbers is that we're charging people 4.2 charges. And so if somebody has 4 charges in Superior Court and they miss 1 court date, it's marked as 4 failures to appear. And so it kind of skews some of those numbers. But what Judge Staub said is right. We don't know why they're failing to appear. So that's where that investing in community resources and that reaching in comes from. We go in, we talk to people, we ask them, why did you fail to appear? What's going on? And people will say, well, I didn't have anywhere to live, or I didn't know it was coming because I don't have a phone, or, you know, whatever. Somebody stole all my stuff. I have an active addiction. I mean, I'm sure you judges have heard all of these things and more. But having the peer supports and the reach-ins and the asking those questions, why did you fail to appear? And then addressing those issues is what's gonna change the whole dynamic.
Thank you. Any other comments from the community before we let 2 members make final comments? All right, Carrie.
I was just going to ask where we go from here, because we initially thought we were going to have 3 meetings. It doesn't feel like we're quite done yet. And so I was just curious, where do you see this going from here?
Yeah, this is the flexibility that I mentioned at the beginning of this meeting. So yeah, we initially thought 3 meetings we'll have everything solved. Surprise, we're still working at it. So part of why we need another meeting is because JFA needed to have our recommendations so that they can build that into their forecasting as different options. And so we're working with JFA and Vera to juggle schedules and see when that next one will be scheduled for us to review the jail population forecasting. At that point, it will be sort of up to us to take that information into account and decide, based on the forecast for the future, based on what we think is feasible locally, what are we going to recommend that our Board of County Commissioners invest in, and then we'll finalize those recommendations. So that could be done in the 4th meeting, or it might take another half meeting to finalize that. And we will continue meeting as committees through November to finalize these initiatives that have been generated today in our pending investigations, but that should be all wrapped up by November. And I will be emailing you all soon to finalize the 4th meeting with the jail projections. Great question, thank you. Brian.
I just wanted to comment on the space between Nick's comment and Judge Staub's comment, that to me, the bridge to that space is pretrial community supervision, so that there's another option other than simply more money than they can afford. And just to go to Director Sparber's comment, you have to do that with an actual assessment of their risk, needs, and responsivity. If someone is so dangerous that you need them on EHM 24/7, then probably they're not a good candidate for that. So we can do that, customize it to the person to keep the community safe, do the reach-ins and all the navigator, and we can do that. And if it's 70% of the jail, that is just a huge opportunity. So I really appreciate the support for that.
Wonderful. All right. Before anyone has any other ideas, Curtis, I see you.
Just a little one. I would just like to see more standardization when it comes to when cases are requested for continuances. There seems to be like a wide range of opportunities there to go back and forth. And secondly, I brought this up earlier, I just want to make sure this is documented. Accountability for our judges and prosecutors of how they sentence people to whatever they sentence them to, and transparency of that process so that people in the community can see that and understand why it went the way that it went.
Wonderful.
So.
All right. On that note, huge thanks to Vera for being here, and a huge heartfelt thanks to our all around the table.